meeting of the Princeton's. Okay, this is the regular meeting of the Princeton Zoning Board of Adjustment be held electronically via Zoom on June 23rd, 2020. Section Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently placing the service of the Princeton Zoning Board of Adjustment. Such notice has been placed on the official bulletin board at the municipal complex and by transmitting a copy of the notice to the Princeton Packet, Town Topics, The Times, Trentonian, and by filing a copy with the clerk of Princeton in 21, and has been posted to the municipal website www. Oops, sorry. Oh. www.princeton.gov. Pursuant to Executive Order 107, due to the state of emergency in New Jersey regarding COVID-19 coronavirus, notice that during the declared state of emergency, all regular and special meetings of the Zoning Board of Adjustment will be held electronically via Zoom, was transmitted to the Princeton Packet, Town Topics, The Times, and filed with the clerk of Princeton on the 24th day of April 2020. Such notices have been placed on the official bulletin board at the municipal complex and on the Princeton website and are maintained throughout the year by transmitting a copy of same to the Princeton Packet, Town Topics, The Times, Trentonian, Comcast Media, and by filing a copy thereof with the clerk of Princeton. Notices have been placed on all window doors of the municipal complex. Okay. Claudia, can you call the roll, please?
Ms. Coulson,
Here.
Mr. Davich, Mr. Floyd,
Here.
Mr. Shriver,
Here.
Mr. Tenenbaum, Mr. Cohen,
Here.
Ms. Chen,
Here.
Mr. Stein,
Here.
Andana Tiana.
Yes.
Thank you.
Okay. You can excuse me 1 second. I have a little computer glitch here. I will be back momentarily. Okay.
Eve, you better be checking the paperwork.
I am looking.
You might be taking over here.
I might be. Should I jump in and just clear the resolution, memorialize the resolution, or?
That'd be great. Eve.
Yep.
Thank you.
Board members, there is one change that I'd like to propose to the resolution. This request was made by the applicant's attorney, but I've reviewed it with staff and we think it's a good idea. Several spots in the resolution, there's a reference to the lot and block as lot 1 and 6. consolidation of the lot was a requirement for them to get approval on their accessory structure. And in Derek's memo, he indicated again, the lots would need to be consolidated. Apparently, in fact, they were already consolidated when the application came to you. And I think zoning staff just had not received a copy of the deed. So the suggestion is wherever we see lot 1 and 6, it would instead say formerly lot 1 and 6, now consolidated lot 7, which is accurate. And that's the new lot number for the consolidated lot. So the request was made, can we make that change? And that seems to be a good change because it's accurately reflecting what the facts are. So hopefully that's acceptable to everyone.
So it's case Z 21-041, address 51 and 85 Mason Drive, and block 7804, and I guess we'd say amended to be called lot 7.
Correct.
Is that the right way to put it?
Yeah.
Would anyone like to make a motion to memorialize this?
So move.
Do I have a second?
Second,
Who is second?
Stein, second.
Hey, were you
I'm
at
very
the-
sorry. I'm back. Sorry.
No worries.
We're glad you're
Yes.
back.
Claudia,
Okay.
was Mr. Stein at the meeting when it was approved?
He was at the meeting, but
He
he
was.
did not vote on that.
Okay, well, then he can't second it, so,
I'll second it.
okay.
So
Roll call.
roll call, yeah.
Colson, Ms. Colson,
Yes,
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Ms. Chen,
Yes,
Chairman Cohen.
Yes.
Thank you.
I pass the baton.
Thank you.
to you.
Okay. Eve, can I make a request if you would? Could you read from the agenda? I don't have it up on my screen. So I guess our first order of business, we have one resolution this evening.
We've
Mason
already
Drive.
taken
See,
care
we
of that.
did it.
Steve.
We did it while
Was that the
you
one we
were-
just did? I'm sorry.
Yes, we did
Okay.
it while you were
So our-
reconnecting.
I'm sorry.
No worries.
Okay, so our first hearing this evening is for Edgerton. Could you read that, please?
Yeah, it's 176 Edgerstone Road, block 9303, lot 1, in the R2 zone, and it is Z 21-005. Should I read the whole thing, or is that?
No, that would do it. Now, this case was first heard at our May 26th meeting. It wasn't heard. It was carried to the June meeting. And at the June meeting, we ran out our special meeting. We ran out of time at the last one. And so we're picking it up this evening. I believe all the notices have been taken care of.
That's correct.
Okay. Derek, do you want to sort of give us an overview?
Yes, sir. Thank you. Good evening. The applicant, the Hunt School, is the owner of 176 Edgerstone Road. It's located in the former Princeton Township. It's in the R2 zone. They are seeking a use variance pursuant to NJSA 40:55D-71 for a use that is not permitted in the zone. The required minor site plan has been submitted. The application is seeking a temporary approval to convert the Mason House, which is a single-family dwelling, to a temporary office use to be utilized by the Hunt School. The applicant is requesting that this temporary office use be limited to the period of the COVID-19 health emergency. The site contains about 1.9 acres. It's the head of the Mason House, which previously served as the head of the school residence. It's located across Wynant Road from the Hunt School. The site improvements include the existing house and a driveway. The surrounding uses are residential. the
Mr.
northeast and
Bridger,
south.
I'm so sorry to interrupt you. I should have sworn you in, so
I'm
I'm
sorry.
going to do it now. My oversight. Do you swear from your testimony this evening will be truthful?
Yes, ma'am, I do. Thank you.
Thank you.
Some history on the case. The municipality was approached by the Hunt School in July of 2020, and they had requested the use of the Mason House as office space for workers from the Hunt School who were displaced by the need to expand the school's infirmary as a result of the COVID-19 pandemic. The municipality allowed the Hunt School to temporarily use the Mason House as an office space, and a neighbor contacted town in late October about whether the office use was permitted. The Hunt School was advised they would need to apply for a use variance to continue the use. That's why we're here tonight. They're proposing to use the single-family house as a temporary office use, would provide office space for 10 existing Hunt School employees. It's currently being used. Minor interior safety upgrades would be installed, such as carbon monoxide detectors and guardrails on the balcony. No exterior site plans are proposed. The temporary office use is not a permitted use in the R2 zone, and the applicant is seeking a D1 variance. And this variance shall only be granted by the affirmative vote of at least 5 members. No other vote or relief may be granted under such terms of this section unless such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan. Special reasons to justify the granting of the relief requested as required by statute. These reasons must be shown to be unique or peculiar to the property for which variance is requested and not generally applicable to neighboring properties. And reasons why the strict application of the zoning prohibition of the requested use would deprive the applicant of reasonable use of the land or the buildings involved, and evidence that the requested relief may be granted without detriment to the public good or impairment of the intent of the zoning plan, which would be the master plan and the zoning ordinance. They have requested numerous waivers on the site plan, and staff has no objection to granting these waivers. The applicant should address parking at site, on the site, and the applicant does indicate that no new employees are hired. These are existing employees, and should just address where they'll park in addition to the use testimony. So that's brief synopsis of my memo. If you have any questions, I'd be glad to address them.
Okay, thank you. I believe Mr. Goldman, yes, you're muted.
Yes, I am.
Okay,
Thank
okay.
you.
You're welcome.
Thank you. Thank you very much. Hello, everybody. I'm Richard Goldman of Faegre, Drinker, Biddle and Wreath, and been counsel to the Hunt School for many, many years. This is a bit of an unusual application because it's for a temporary use variance, not a permanent use variance. And it really arises exclusively out of the COVID-19 pandemic and what flowed from that in terms of emergency orders, CDC guidelines, and most importantly, and this is what I wanted to emphasize, the health of the children that go to the Hunt School for an education. The Hunt School is both a day and boarding school. We have students from all over, international students that live on campus, and we have a fiduciary obligation to them, almost a parental obligation to maintain their health. In the summer of 2020, as you all can sadly remember, the pandemic was raging. Things were bad. And in order to try to protect the students, it became apparent that the Hunt School needed to expand its infirmary for a number of reasons. And the head of school, John Brom, is here, and he'll testify to those. But I wanted to lay out at the very beginning that the special reasons here are the COVID pandemic and the need to protect the health and well-being of these students. As it turned out at that time, the second floor of Russell Hall, which is the main building of the Hunt School, was deemed to be just an ideal place to expand the infirmary. And why do I say expand? And John will explain this as well. But now if a child has a fever, a cough, is short of breath, you have to immediately isolate that child. So they have to come out of the dorm. They need a place to sleep. We have a place for a nurse to sleep. So we needed this significantly expanded facility. At the same time, and the Hunt School lives in a very tight quarters and very, very tight for space. The Mason House, which for many, many years, which is directly across the street from the Hun School, Russell Hall, was vacant. And it was vacant because it had been the head of school's house. And to our great fortune, Betty Johnson donated her house, which is 2 doors down, to the Hun School with her wish that it be the new headmaster's house, the head of school's house. And so John and his family had moved into that house. The Mason House stands empty and was ideal as a location to relocate the 6 to 10 employees that had formerly been in offices on the 2nd floor of Russell Hall. We knew that this was the R2 zone and it wasn't permitted, but we thought the medical emergency that we were all living under might get some consideration. So we wrote to Michael Laplace. He brought it to the council attorneys. And in July, basically, we were advised that we could utilize the space to expand the infirmary and move those existing employees literally across the street, walk across the street, and you're there. And so we did. We built out that infirmary. We changed those offices into an expanded infirmary. The 6 to 10 employees were moved into the Mason House. It's 9 to 5. No new employees are added. It's the same number of cars that come to campus every day. And what I wanted to do before John testifies is maybe we can give John DePasquale control so he can bring up a couple of slides so I can just situate us so we know where we are. There we go. Okay, so
Do we need to swear in Mr. DePasquale? Oh, no, you're just using his screen. Never mind, sorry.
yeah, he's just
Okay.
showing. Okay.
Okay.
And we should probably mark this slide presentation. I would think there's 4 slides, but I would think
So we'll make it
call
exhibit A1? Okay.
Yes, and I'll just refer to page numbers. And really, it's very simple. I just wanted to show us, identify where we are. And so this is page 1 of A1. And on the right-hand side of that colorized plan, you see what is the property of the Mason House. Right, and that's Wynant Road that runs along the curved face. I don't know, John, if you can use your cursor, there you go. So that's Mason House. Wynant Road is running along the curved face, and Russell Hall is directly opposite right there. Those of you familiar with the campus, there's that circular drive between the two. All right, let's just then quickly go to the next slide. The next slide is essentially the same thing, but in survey form. I want to go to the slide after, which will be slide 3. That's a photo of the Mason House. And as you can see, unlike almost any other residential house, you'll see the front of Mason House is the Hun School parking. The parking lot is in the E zone and is an appropriate and permitted use. And the Mason House sits on that lot. The Mason House does have its own driveway, which we can use for 2 or 3 or 4 cars, or if that's of concern to folks, those folks can park out here in this parking lot that's right there. But my point only being, the nature of the Mason House is very integral to the campus operation. So with that in mind and with that background, I think what I'd like to do is bring John Brome up to just explain a little bit more about the needs and the functioning of the infirmary and these offices.
Sure,
Mr.
Yeah,
Brown, do you
John,
swear?
yeah, go ahead, sorry.
It's okay. Mr. Brown, do you swear from your testimony this evening will be truthful?
I do.
Thank you.
I
Thank you
think
for,
we can, yeah, before you start, John, a couple of things. First, I think we can take away the screen. I think everyone's had a chance to see it, so we can all see each other. I think folks like that better. And John, before you start, can you just tell the board, what your role is at the Hun School?
yes, I'm the head of school at Hun,
And how long have you been there?
12 years.
Okay. And as the head of school, you're essentially the CEO, the chief officer of the school. Is that correct?
That's correct.
Okay. And you're familiar with the use of the Mason House, the needs for the infirmary through your position as head of school.
Yes, I am.
Okay. So let me take you back to the summer of 2020. And can you tell us a little bit about how we got to the request for use of the expanded infirmary?
Right. Well, those were scary times for Hun and for every other school, as you can imagine and remember. We really wanted to hold school on campus, but we had all these very real dangers to the health and welfare of our students in doing so. And we had to take every possible measure to protect the kids. And one of the first things we realized is that we were going to need quarantine and isolation and testing space for students. Those things are required by the state regulations and the CDC and by all of the medical consultants that we worked with. And what that meant would be we needed a space large enough for kids to be examined, a place where they could sleep because they might be in quarantine for up to 14 days at that time, where they could get 24-hour nursing care, where they could eat, where they could bathe. The testing was also an important component for us because we ended up this year giving 7,000 COVID tests, if you can imagine. And we thought that was just integral to the safety of our kids. And none of this could happen in what we presently call our infirmary, which is also in Russell Hall. It's a little the only triage space is a little 8x8 space with no place for a kid to stay overnight or eat or bathe or anything like that. So we very quickly realized we're going to need a much bigger, different space to take care of the kids under all those circumstances. And we did a review of the campus, and the only place was on the second floor of Russell where you could have bathrooms, where you could keep boys and girls apart, where there was enough room for examination and a waiting room and everything else that you'd need. But as Rich said, that space was already occupied by 10 people who were working in offices there, and they needed to go someplace. And because we had recently moved out of the Mason House to the house 2 doors down, Mason House was sitting there empty right across the road, and without much jerry-rigging, it could accommodate those 10 workers, and it wouldn't be any noise, it wouldn't be any added traffic, wouldn't be any extra employees, and it seemed like a perfect solution. So that's when we came to the town and asked, could we please have temporary authorization to do that just for the safety of our kids in this kind of crisis situation. And it was granted informally. And I know that's why we're back here, is to do it formally. I can tell you,
John, so you actually went ahead and built out the infirmary space at some cost, I assume?
We did. We built it out. We used it extensively. The place was full of kids all the time trooping in for testing. And we did have, quarantine and isolation. The regulations require any student who shows any symptoms that could be COVID to be isolated and tested and kept isolated until it could be shown that they were safe. Or in any kid who was exposed to COVID, known to be exposed, a close contact, they had to be quarantined for 14 days. And now that time's been reduced. And any student who had traveled, we have borders coming in from all over the world, of course, and they'd have to be quarantined before they could really enter into the community life. And it had to be someplace separate from all the other kids. That's why Russell worked so well for us and really was the only place that would. And so we used it extensively all year long.
So let me ask you, John, about the across the street now. So what was going on at Mason House? Did you have to build office space? Did you have to do additions? I mean, or were you able to just use the Mason House basically as is with no real exterior improvements?
We really used it as is. I don't know that there were any changes that I recall, at least. Knowing that it was a temporary use, people were, they had their offices and children's bedrooms and stuff like that, but it did meet our needs.
And it was reviewed by the code officials in town and authorized for that occupancy.
Yes, I think Mike, our facilities director, kind of can speak to that, but yeah.
So the people that are in there were those 6 to 10 people at any given time that worked in the second floor of Russell Hall?
Right.
And there were no new people added.
No.
And in fact, I mean, at various days, rarely are they all there at the same time.
No, because of distancing requirements we had most of the time throughout the year. I think we had half of the people there on many days.
Okay, and the hours that they are there, when would they be in that building?
I think typical would be 8 to 4, 8 a.m. to 4 p.m.
Okay, weekends?
No.
Okay. Now, recently, it was after we filed our application, but before tonight, the governor issued an executive order that did 2 things. It terminated a section that was called the health emergency, but it left in place what had originally been the state of emergency. And it referenced specifically the special needs of schools and the CDC guidelines. So I wanted to ask you, under the current orders of the governor and the CDC guidelines, do your requirements for mitigation continue to protect the kids?
Absolutely, they do. We've had to become sort of experts in what the government is saying, what the governor, what the state, what the federal government is saying, and the state of emergency still exists, and all the Department of Education guidelines and requirements about everything from masking to isolation to quarantining, those things still stand.
And perhaps more significantly, is it your opinion that there continues to be a health risk due to COVID to the students?
Yeah, I'd say there certainly is, because we still will be bringing in students from all over the world in the fall. Some of whom have been vaccinated, some of whom have not, some of whom maybe have had a deficient vaccination that hasn't been approved by the World Health Organization. And we expect other students in our community besides the borders to be unvaccinated as well. So,
and do you feel, John, that the methods that you've adopted and the mitigations you put into place has been relatively successful?
Yeah, we're very proud of it. We have a total of either 3 or possibly 4, because we're not sure about 1, transmissions on campus in the entire year, which is pretty good when you're dealing with hundreds of kids in and out, and dozens and dozens of cases of our own students off campus in their own lives, but not at school. We've kept school very safe.
Now, in terms of sort of the folks who work in Mason House, if they were driving to the Mason House, they would have been driving to the campus across the street in any event. Is that correct?
Yeah, that's correct.
So no new cars were generated as a result of this move?
No.
Okay. What about sort of noise? And I mean, what kind of impact do you find to be to the neighborhood by the occupancy, this temporary occupancy?
I don't think there's a bit of impact. I think occasionally those people, because we haven't told them they can't, they park in that long driveway from Edgerstone Road down to the Mason House. rather than parking in their usual parking places on the street. Every use is quiet. They don't really have visitors to speak of. They're just office workers. It's probably quieter than my Scottish Terriers used to be when I was living there.
Yeah. And nobody's there at night playing music and having barbecues, I assume.
No, it's not an entertainment place at all.
So let me ask you to look into your crystal ball. I mean, I know obviously in late August, early September, the students start really arriving for the first semester. Do you feel that you will continue to need these mitigations that are currently in place for the first semester coming up?
I strongly believe that. I think every indication is that both government regulations and our own medical authorities and our own common sense will require us to be isolating, quarantining, and testing throughout the fall.
All right. And so if the board were to, I mean, when you say something's temporary, it's always good to have an end date. If the board were to suggest as your temporary relief that this would cover the first semester, because I assume it'll be pretty hard in the middle of a semester to start rebuilding and refitting. But let's say it would cover this first semester, let's say to the end of December of this year, with perhaps an ability to come back to the board at that time if an extension was needed because circumstances have either deteriorated or improved. No one has that crystal ball. But, there's a new variant out there that people are worried about. So at least if things had worsened in the fall, and I think the fall is a dangerous time for COVID, you would like at least the ability to come back and ask for an extension. But absent coming back, if the thing terminated at the end of December, that would be a reasonable temporary period for you.
Yeah, and that's exactly where our own planning is kind of headed, based on the opinions we're getting from our experts. We're aiming at keeping things at the same level of vigilance through the fall and then hoping and expecting an improvement.
Okay. Thank you, John. I wonder if anybody on the board has any questions.
I have a
for John?
question. I have a question. So if this extended, if you're offering basically to come back to the board after the first semester, when date-wise would that be?
Well, the semester ends in late December. And I guess, again, it's a little uncertain about when we would know that an extension's needed, if there's something new popping up. But I would estimate maybe December 1st.
I guess, Mr. Chairman, what I would suggest is that if the board was inclined that the temporary use would run till the end of December, but if the school needed an extension, they would have to make that request by mid-November so that at least there'd be a time period for it to get on the board's agenda and staff to consider it in the report.
So you would actually propose then to come in at our December meeting?
Yes.
And usually the December meeting is usually, because of the holidays, in the middle of the month. I don't know. I think Claudia, when is our December meeting? She's muted.
I'm
Derek?
checking right now. Give me 1 second.
Okay, go ahead.
December 15th.
December 15th?
Yeah.
Okay, so you would make application in enough time to
Yes.
come in and be heard at December 15th?
Yes, we would.
Okay. All right, thank you.
I have a question. What is the regulation that governs the schools distancing and regulations about quarantining? Is it the state of emergency or is it an internal decision?
No, there were guidelines and regulations from the New Jersey Department of Education, which then are referenced by the New Jersey Department of Health and the Princeton Health Department.
So in essence, those would have to be lifted before you could go back to your normal So one way of knowing when you might need to come back to us is when those regulations are lifted. Otherwise, you would need to stay there until those regulations are lifted, is that right?
Yeah, we really have no choice until that happens.
Yeah,
Thank you.
and of course, I think it's the governor in his last executive order, when he continued the state of emergency, he actually specifically referenced continuing the state of emergency because of the need for mitigations for things like schools. He actually mentioned schools.
Thank you.
There is a possibility, though, that you might choose to vacate the house sooner than the end of December.
Again, everything is possible. And if we did, I think that would terminate the temporary use variance because we would have abandoned it. I have to say, I would be extremely surprised if we were able to do that, because it means you would have to refit the area of the current expanded infirmary or build out some other place, which would perhaps require its own approval. So I don't see this happening before the end of December, and that's why we've sort of targeted that as a time for another look-see.
Okay, that's fair enough. Thank you.
I have a question, Steve. Would you consider it actually being into December, the earlier of into December, or the governor listing the emergency?
I'll tell you, it would have to be more than just the governor lifting the emergency, and I'll tell you why. John mentioned it before. There are the Department of Education requirements, Department of Health requirements that all impose on the school these obligations for mitigation. And in our application, I want to correct a little bit of confusion. We may have inartfully used the term during the health emergency.
Yes.
But we use that term with small h and small e, because to us, we had a health emergency at the school. We had kids, we were risking COVID. We weren't referring to the governor's executive order for health emergency. So I believe that as long as we feel there is a risk to the student's health that is codified by the Department of Education, the CDC, which is another big one, and the Department of Health in New Jersey, government regulations. I will say this, if all the government regulations are terminated, then I agree with you. Then we could stop. The reason I think it's better to give us a date like December, because let me give you an example. Let's say on November 20th, the governor announces that all regulations regarding COVID are now terminated, and the CDC says there are no more regulations. Honestly, I need a few weeks to modify, right? I can't just the next day shut down the infirmary. And that's why I was suggesting having a date certain is much more realistic as to what could possibly happen here. But honestly, I don't see that happening by the end of this year in any event. But I think it at least gives us an end date to target.
Okay, Michael, are you satisfied with that?
Yeah.
Okay,
It's a bit nebulous, but there's no way around it.
okay. Are there any other board members who have any questions?
Yes, I have a question for Mr. Brom.
Go ahead.
What are your plans after you vacate the Mason house, for that house?
We don't have a plan yet. And we didn't have a plan before we moved in there either. This house that was given to us, I don't know if you're familiar with it, but it is a, you know, a very grand house, perfect for entertaining, and it was given to us specifically to be a head of school's house. And so we thought it was appropriate for us to move in there as quickly as we could, but we haven't, at the moment, the house is zoned residential. I suppose we could rent it out. I don't think we have another purpose for it at the moment.
You know, let me help supplement that a little bit. For example, under the R2 zone, we could rent that house to, let's say, 5 or 6 young teachers who wanted to share a house. Frankly, we think that would be much more of an impact on the neighbors than this particular use. But I did want to mention that back in, and this goes pretty far back in December of 2019, so pre-COVID, we had made an application for review at the planning board to consider bringing the Mason House property into the E zone. And we actually had a full presentation before the board, and the planning board voted unanimously to recommend that change to the governing body. And that was codified in a letter that, a memo that Michael Laplace wrote to Mayor Lempert at the time. This was back in June of 2020. Basically indicating the unanimous recommendation of the planning board. Unfortunately for us, between the press of business for, as you all know, the affordable housing cases that started to surface and the ordinance requirements for that, we didn't get to it. And then COVID hit and everybody had so much to do. So that's pending, and we do intend, when things calm down a bit, to continue that request. We believe that the council will move that forward. That will in turn allow the Hun School to begin to plan in a much more comprehensive way for a use for that property. But frankly, that's zoning. The only reason I talk about it is I think the unanimous recommendation of the planning board sort of indicates that any educational use of that property is not detrimental to the zone plan. I think the planning board has said, we think it's a good idea. But it's not really part of this application. This application really rests on the health emergency that's created by COVID and the students.
Thanks.
Just to clarify, if the school decided they wanted a further extension, is the thought that they would file a new application by mid-November?
Well, that's what the question I was going to ask you, Karen, as to whether or not there's a way, since this is a temporary variance, whether or not there's a way for the board to retain jurisdiction and actually maybe even schedule us for December 15th to come back and say, yes or no. I mean, this is what we're requesting or we're not.
Well, I think,
and that might avoid, the need for a new application and fees and all the rest.
well, I mean, I don't know if Derek has any comments on that. I think certainly the board could retain jurisdiction of this. I think the question would be, would you need to renotice? Because even though the board would have jurisdiction and you wouldn't be filing a new application, you would simply let the zoning officer know, we do wish to come back.
Well,
I don't
Karen,
know
that's why I was saying you might actually notice it today. You could say, this is going to be on the December 15th
Right.
agenda, and we'll come back. Same as if you carried a hearing.
Well, I mean, I think legally that's possible. I don't know if zoning staff would want to keep posting, telling people, it will be on December 15th, reminders at subsequent meetings, to remind people at the December 15th meeting, this will be heard, and you'll come back either way. You'll come back and say either, we don't need any extension, or yes, we do.
Yeah, that's what I was thinking.
Mr. Goldman, would you be amenable to doing a regular notice not certified by to people.
Sure, yeah, no,
update that?
yeah.
You mean
We're
just
happy to do-
first class mail?
Yeah, we're happy to do that. You know, I'm not trying to avoid the notice. I'm just trying to save some money for the school. And
Yeah, I just want to make sure that the residents who are
yeah,
concerned
that's
are.
fine. That would be fine. That would be totally fine. So, I mean, I guess, I think you have at least somebody from the public that probably wants to speak, but we think we meet all the criteria for this unique variance because it's temporary. As I said, I think the disease itself is the special reason. I think the health and safety of the children are a special reason. We don't think there's any impact on the neighbors. We think this is very consistent, this temporary use with the zone plan, because it's temporary and because it's not imposing any new traffic, any new employees. It's as innocuous as you can get, and it's temporary, and it's based on a horrible disease that requires drastic action to protect students. But I'll let you hear from the public and anything
Well,
else.
are you, Mr. Goldman, are you done with your presentation?
I am, unless the board had questions. I have Mike Chakowski's here, who's our Director of Facilities. If you had questions about the floor plan itself, I doubt it, but I had him here in case you did. But other than that, that is our presentation.
Okay. Board members, any other questions? Okay, so hearing none, we'll open this up to the public. Claudia, Eve, have anyone identify themselves, raise their hands?
I see somebody, is that Mr. Fenwick?
Yes,
And did you want to speak, Mr. Fenwick?
I did.
All right. If you would give us your address, please.
102 Russell Road. Princeton,
And
New Jersey.
do you swear or affirm any testimony you give this evening will be truthful?
I do.
Thank you.
So my name is Edward Fenwick. I live at 102 Russell Road, and we have bought the property of 176 Edgerton Road, also known as the Mason House. Thank you for the opportunity to speak to this variance request. My comments will address first, the required positive and negative proofs for granting a D variance, and second, the impact of the COVID-19 public health emergency on the Hun School's request. My comments will take about 10 minutes. The municipal land use law, as you know, clearly specifies the proofs required for granting a D variance, the positive special reasons and negative criteria. The special reasons must be shown to be unique to the property for which the variance is requested and not generally applicable to neighboring property. For special reasons, most broadly, the applicant must prove that a project advances one of the 17 purposes of zoning listed in the municipal land use law. The Hun School has not specifically put forth any special reason that this request should be granted. COVID-19 is not one of the 17 purposes of the zoning law listed. I won't go through all 17 of them. You know them, and as I stated, there was no reference to them. As an alternative rationale for a special reason, extreme and undue hardship can exist where a condition of the land results in economic inutility and the property cannot reasonably be used for its own purpose. 176 Edgerton Road has always and continues to be perfectly suited for its R2 purpose. 176 Edgerton Road, the Mason House, can reasonably be used for its own R2 purpose. An inherently beneficial use can also be an alternate rationale for a special reason. If a use is held to be inherently beneficial, it presumptively satisfies the special reason. The land use law defines an inherently beneficial use as one which is universally considered of value to the community because it fundamentally serves the public good and promotes the general welfare. Use of 176 Edgerton Road to provide office space for Hun employees serves the Hun School's purpose It is not universally considered to be of value to the residential community in the in which the property is located. It does not serve the public good or promote the general welfare of the residential community in which 176 Registrum Road property is located. The site suitability test established through 2 New Jersey Supreme Court cases further refines the special reasons requirement for uses that are not inherently beneficial. Cole versus the mayor and council of Fair Lawn, New Jersey established the principle that the use must promote the general welfare by being particularly fitted to the particular location for which the variance is sought. Again, particularly fitted to the particular location for which the variance is sought. The building on 176 Edgerstone Road is particularly fitted to be a single-family resident in an R2 zone. It is not particularly suited to being used as an office. Medici versus BPR established the requirement for an enhanced quality of proof, and the applicants need to show that there has been substantial change in the character of the community since the adoption of the master plan and zoning ordinance. The character of the community in which 176 Edgerstone Road property is located is residential. There has been no substantial change in the character of the community since the adoption of Princeton's master plan and the zoning ordinance. The Hun School's variance application and supplement is silent on special reasons. And tonight, the only special reason that was stated or connected was the COVID pandemic. In the school's application, they do comment on several reasons for the requested variance. And they repeated most of those here tonight. One, the stated inadequacy of space in buildings on the Hun campus. But this is not unique to the Mason House property and therefore has no bearing on this variance request. The health and well-being of Hun students and staff of the Hun School has got a lot of words here tonight and through the documents. But again, that is not unique or relevant to the Mason House and has no bearing on this variance request. The existence of the pandemic. Again, it's not unique or relevant to the Mason House and has no bearing on this variance request. The picture that Mr. Goldman showed of the Mason House with the car in the parking, that suggests ownership and vacancy and proximity and convenience of the Mason House to the Hun School is some sort of special reason. But again, it has no bearing on this variance request. Special reasons must be focused simply and solely on the use of the Mason House for a purpose prohibited in the R2 zone property. For the negative criteria, the applicant must show that the variance can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance. The map on the first slide of the Hun School PowerPoint, which was presented here today, misrepresents the neighborhood community in which the Mason House exists. The map excludes most of the R2 properties to the east of the Mason House and many of the R2 properties north of the Mason House. The slide creates a deceptive impression of the Hun School's location within and physical relationship to our neighborhood. The neighborhood has more than 120 single-family homes, all on R2 properties. A diverse community of residents occupy these properties. Granting a variance to use one of the houses in the neighborhood for a non-residential purpose would be a detriment to this community by denying it additional members and contradicting the residential character of the neighborhood. I found it particularly enlightening and reflecting on the misunderstanding of a neighborhood when Mr. Goldman said the neighbors would be better off, would be disadvantaged with 5 or 6 teachers living in the house. That's what a neighborhood is. They're there over the weekend. They walk their dogs. We know each other. We visit each other's houses. That is not a disruption of the nature of a neighborhood. That is a neighborhood. We're disrupted by having 6 people that work, or 6 to 10 people working 8-4 and disappearing. The nature of the zoning plan is dismissed with that type of attitude. The Hunt School needed to show why the strict application of the municipal land use law would deprive the school of reasonable use of 176 Edgerton Road. They have not done that. The Hunt School has failed to put forth a legal argument for the proposed use of the Mason House. Regarding the public health emergency impact on the Hunt School's request for temporary D variance. And I apologize, but this is all Mr. Goldman and others brought most of these points up, but I want to bring them out in sequence. In 2020, as Mr. Goldman said, the Hunt School was allowed to use the vacant Mason House as office space for employees displaced by the expansion of the infirmary due to the COVID public health emergency. It's important to note, as I think has been noted here, the permission was not granted by 5 favorable votes of the Zoning Board of Adjustment as required by the municipal land use law. There was no notification of abutting neighbors, and the infirmary located in Russell Hall was described as inadequate and in need of expansion in Hunt's 2010 master plan, and once again in its 2018 master plan update. Let me repeat that. The expansion, inadequate and in need of expansion, was identified by Hunt in 2010 in their master plan, and again in their 2018. I'm not arguing against an expanding infirmary. I'm just saying this is not a new issue. In January 2021, the Hunt School submitted an incomplete variance request identifying, quote, the COVID-19 global pandemic and related state of emergency in New Jersey. In March 21, the Hunt School submitted the required documents in support of the variance. The quote, rider included in this submission stated, the Hunt School is requesting a temporary use variance for the period of the COVID-19 health emergency. On June 16th, 21, the school submitted a supplement to the record. It argued that there is still a public health emergency and it will continue for an indefinite time. The supplement claims there is a misapprehension. The supplement I'm referring to is the one that was submitted on June 16th. And Mr. Goldman repeated most of this today here, that there was a misapprehension about the public health emergency in the variance request. The root cause of any misapprehension is due to the Hunt School's effort to consistently cloak this variance request in COVID-19 concerns. This board must look through that obfuscation and focus on the zoning issue, a request to use R2 property for a prohibited use office space. The existence or non-existence of a public health emergency has no bearing on the continued use of the Mason House for a purpose that is not allowed in the R2 zone. In conclusion, the applicant has not offered any proof of the positive special reasons needed for the board to approve the request for a temporary D-use variance. The Hunt School claims there is no negative criteria of the requested variance. However, there is. The Hunt School needed to show why the strict application of the municipal land use law would deprive the school of reasonable use of 176 Edgerton Road. They have not done that. There is strong opposition in the neighborhood to the use of 176 for office space. And for those reasons, the board cannot and should not grant the request. The Hunt School has had over 1 year to find other facilities to office the employees currently using the Mason House. I request this board to direct the zoning enforcement officer to issue a cease and desist order immediately requiring the Hunt School to stop using 176 Edgerton Road as office space. Let me close by saying I admire the Hunt School's passion and concern for protecting its students, and they should do all they can, obviously. I'm just saying that is not connected to what you are here to do. Thank you for your time.
Thank you. Is there anyone else who'd like to speak to this application in the public, from the public? Claudia, Eve, is there anyone else out there?
I don't see any indication that there's anyone else. If anyone else is
Okay.
interested, please raise your hand or unmute yourself, but I don't see anybody else doing that.
Okay, Hearing and seeing no one else from the public, I'll close the public portion of the meeting. Mr. Goldman, do you want to make a closing statement before we go into executive session?
Yeah, just for a minute, if I may. I appreciate the diligent research and legal scholarship of Mr. Fenwick. I'm not sure that all of these standards apply as directed or as specified for a temporary use that we're asking for. Obviously, if it's a temporary use, it reverts back to its permanent use. And so the notion of changing the character of the neighborhood, a lot of these things just don't apply to a temporary use. But I would say that we have definitely made out all of the criteria in any event dealing with the lack of impact to the negative impact to the neighborhood, the planning board recommendations with regard to the zone plan, the special reasons and the inherently beneficial use. I mean, we're a school and we're protecting children's lives. I think that's health, safety, and welfare is definitely one of the principles of the municipal land use law, and we are certainly promoting that. So we would appreciate consideration of this. We think it's really vital to the students at the Hunt School, and I thank you for your time.
Okay. Well, I guess it's time for the board to discuss this, but first, Karen, can
Yes.
you give us an opinion of Mr. Fenwick's argument?
Well, it does seem to me that under the purposes of zoning, and it's actually 40:55D-2A, which is a very broad category. And it says it's one of the purposes is to guide the appropriate use or development of land in a manner which will promote the public health, safety, morals, and general welfare. As I understand it, the argument the Hun School makes is that the expansion of their infirmary has necessitated the temporary use of this house for office space. And the expansion of their infirmary clearly promotes the public health and safety. I understand Mr. Fenwick's argument that you shouldn't link these and that there has to be some independent, what should we say, reason associated with the house itself. I think given the nature of the pandemic and given the broad language though in 45:55D-2A, it would not be unreasonable for the board to make that link because that is the argument that's essentially being advanced. It's not simply that, oh, the school just decided temporarily because they're doing something else on campus, they just want to use that house temporarily for office. I'll give an example, because they're renovating another building and they're stretched to the max. And so it's just temporary. The argument they've made is that it's directly linked to the need to provide adequate health care to the students in accordance with the CDC guidelines, Department of Education guidelines. So that is the basis for the request. And as I said, I don't think it's unreasonable for the board to recognize that link. As far as impact on the neighborhood, this is, you've heard the explanation from the headmaster, you've heard his testimony, and you've heard what Mr. Fenwick has said. So in that regard, it's up to the board now to decide, do you see any impact? Do you recognize any testimony regarding impact, keeping in mind that it is temporary? It is not a request for a permanent change. It is a temporary variance that in fact, the applicant is coming back to you in December to update you. And at that point, it's certainly within your prerogative to ask additional questions or to suggest alternatives or whatever other concerns you might have at that point, if you're reluctant then to continue it. But that's how I'm viewing it. I don't know if anybody has any questions or has some other concerns, but I think that under that very broad special category, Section A, this explanation, particularly in the context of this pandemic, is not unreasonable. So I think it's within the board's jurisdiction to accept that if you find the testimony credible.
Okay, thank you. Does anyone on the board have any questions of Karen?
Yes, I do, Karen. Is there, apart from that broad description in the law, what sort of cases have come up about temporary variances?
I'll tell you, George, I'm not aware of any, probably because when something is temporary, there's not much motivation there to litigate it. There are some cases where an applicant has said, it's not temporary. Instead, I want to put a time limit myself on the variance. I only want it for 5 years, for example. So I don't want it to run with the land. I, the applicant, tell you that. I only need it for parking for 5 years. But I'm not aware of any cases that are examining a temporary variance issued for, in this case, I guess, 6 months. So I'm not aware of any.
Okay, thanks.
The variance would expire before the case was ever litigated.
Especially now in the courts, everything is very, very backed up. So that's true.
Okay. All right, board members, any comments on this application?
The only question I have is why they need to come back before the regulations are lifted.
Say that again, please, Stephen.
I'm not sure why they need to come back to us before or in December if the rules and regulations of the health departments and the CDC and all those others have not been lifted. Why can't we just wait until those rules are lifted and then have them come back?
Well, Steve, I would say that this is intended to be a temporary variance, and this is a measure of control for the board. If you approve it saying when things get lifted, then it will expire. Okay, but there are various standards that are being applied. There's CDC, there's Department of Education, and at some point, the variance, it runs the risk that it's not really temporary now. It's been extending and extending, and we could be 2 years out and COVID has come back again, or CDC changes something, or CDC says, well, you don't have to do XYZ, but you should do something else. Well, that might be a basis then for the school to say, yes, actually, probably we don't need the variance anymore, but it's mainly because it is proposed to you as temporary.
And we're okay. We're okay.
Yeah, and I think the applicant is comfortable with that. They're also saying that's okay.
That's fine. I accept that explanation.
I can tell you, nobody wants this to be temporary more than us.
Well, okay. Any other questions from the board? Some discussion. Michael?
Still thinking.
Oh, okay.
I guess, with the D variance, without substantial detriment to the public good and will not substantially impair the intent of the zone plan and zone ordinance, I believe they meet that. And that's the real hurdle. Special reasons is something that they should address. They've addressed it as best they can. I don't think this is unique in particular to the property, and not generally applicable to other neighboring properties. But that's not the main hurdle. I think the first thing I read, so I will be voting for it, and with the input of the board's attorney. So I'll be voting for it.
Thank you.
You're welcome.
Anyone else?
I certainly plan to vote for it for a couple of reasons. One of them is I think that COVID is a totally unique and devastating kind of happening in this country. And I think as neighbors, we have to respond in a neighborly way to an organization that has always been a good neighbor. And they're asking for a temporary help to alleviate a terrible problem on their own campus. And it is temporary. So I don't see why you would object to that.
Thank you. I feel the same way. I feel it's an extraordinary situation. They're asking for temporary relief. We reasonable time to get back to us. If something happens there, Mr. Goldman will notify us, but I think this is not in a situation. It's truly a result of a unique emergency, and for it.
Steve, you're cutting out on us.
Oh, sorry. What I said was, again, this is a unique situation, and it's an emergency, and we've given them a time limit to come back to us. And if something happens sooner, they would notify us. And so I'm planning on voting for this.
I just would add that I don't think we can hold the Hun School hostage in a way to the fact that our zoning rules did not include the extraordinary situation of a pandemic and the needs that come out of that. It seems like how they've dealt with it seems reasonable to me. But trying to get it to fit into our zoning language when there isn't anything in there that relates to a pandemic, it's a bit of a job, I'd say. But I think they did that.
Yeah, I can support this as well with the using the health, safety, welfare as a guiding principle. I think they adapted quickly and made the best use of what was available to them.
I move we adopt the resolution.
Yep. Did we lose our chair?
Steve, you're
Me?
muted.
He's muted.
Yes, he's muted.
I'm sorry. Yes, sorry about that. All right, Stephen, you've made a motion.
Yes.
Okay. Do we have a second for that?
I will second it. I think it should And Karen, you can let me know if I'm right. It should be, it's conditioned on them coming back in December.
That's correct. The board will keep
Yeah.
jurisdiction. They will return to the board on December 15th, and they will let the zoning officer know by mid-November if, well, what the status is anyway, so the board can understand what is coming, and they'll also send a notice to neighbors within 200 feet by first-class mail, just as a reminder in case anybody is interested in coming to that meeting and speaking to whatever relief the school wants at that point.
Yep.
Okay.
Okay.
Yeah.
Okay,
Mr. Chairman, Mr. Fenwick wants to speak again.
I'm sorry, I didn't hear that, Claudia. Okay, we have a motion and a second. No other discussion on the motion?
Me, Steve, Claudia was trying to say that Mr. Fenwick had raised his hand and he would like to speak again.
Okay. Although unusual, I'll allow it.
Just note my objection because you've closed the public meeting, please.
I'm sorry, Mr. Fenwick? What was that?
No, that was
No,
Rich.
that was Rich Goldman. He's objecting because you
Oh.
closed public discussion and you had a
You
motion
got a
and a
motion,
second.
you have a
and
motion
second.
and a second on the floor. I think it's
Okay.
inappropriate to reopen.
Karen, your opinion?
Well, I mean, we have the procedural rules we have for a reason, so unless someone's going to be persuaded by more testimony from Mr. Fenwick, you have already closed discussion, you've had your executive session, and you've had motion a second. So it would be very unusual to allow comment at this point again.
Okay, and I think you're right. Mr. Fenwick, I'm sorry, we can't hear you at point. We have to act on the motion before us. Okay.
I think Steve froze. There you go. Steve, you might try shutting off your video because it's probably using up your signal.
What even was?
Eve, why
Okay.
don't you call for the election or for the
Hey.
vote?
Yeah, it's for Claudia.
Claudia.
I'll call
Okay.
roll. So.
Sure. Ms. Coulson,
Yes,
Mr. Floyd,
Yes,
Shriver,
Yes,
Ms. Chen,
Yes.
Mr. Stein,
Yes.
Ms. Deanna,
Yes.
and Chairman Cohen. Is he back?
Yes,
Thank you.
yes.
Thank you. It's approved.
Thank you very much, everyone. Thank you for your time. We appreciate it. And enjoy the rest of your evening. And I only note the irony that we're talking about this virtually because of the pandemic. You're not in a room and we're keeping our kids safe too. So thanks very much.
Thank you, everyone.
Welcome.
Thanks.
Okay, if board members, if my connection becomes unstable, then Eve will take over. If anybody feels uncomfortable with me continuing right now, let me know. Okay, Eve, can you introduce the next case?
yes. It is 270 Lambert Drive, block 8110, lot 22 in the R1 zone. It's case Z20-920.
Thank you. Thank you. Derek, can you give us a summary of your memo? Oh, wait, excuse me, Karen, are all the notices in order?
They are, and the board has jurisdiction to hear the application.
Thank you. Derek, can you give us the summary?
Thank you, Chairman Cohen. The applicants, Ben and Dana Weiss, are the owners of two.
Mr. Chairman, this is Frank Petrino. May I have a moment? Our engineer is currently on his, well, he's not on his feet because of COVID, but he's currently involved in an application in Ewing he will be with us shortly, but I would ask that we are currently number 2 on the agenda, that we be moved to number 3 and that number 3 go forward at this time.
Okay. I have no objection to that. So
Thank you.
the
Mr.
next hearing
Ridolfi?
then,
Mr. Ridolfi, are
Eve?
you there? Bob?
Yes, I am. I'm here.
Okay. And who was your professional, or is that your applicant?
Sure. Jim Kyle, who's on now, his video is off. And I have Bill Giddings, so I saw him earlier. He's the architect. And of course, the applicants, David and Kimberly Bitterman.
okay.
So shall I, so we go on to the third one, 174 Springdale Road. Shall I read that out? And we'll come back.
Yes, please.
Okay. All right.
One thing, excuse me,
Yeah.
Karen, notices in order for this one?
They are, and the board has jurisdiction to hear it.
Thank you, Karen.
Okay. Eve, go ahead. I'm sorry.
It's 174 Springdale Road, block 10602, lot 10 in the R5 zone. And it is case Z21-025.
Okay, thank you. Derek, can you give us a summary of your memo?
Yes, sir. Thank you, Chairman Cohen. David and Kimberly Bitterman are the owners of 174 Springdale Road. They're seeking C2 variance to permit the construction of a detached garage in exception to the required front yard setback and maximum driveway width at the property line. The property is located in the R5 zone. The subject lot is non-complying with respect to the lot area, which is 21,780 square feet is the required, and the existing is 15,309 square feet. The applicant is proposing to construct a 23 by 24 garage, which will front on Ober Road. The garage will require a front yard setback variance. It's a corner property, and as such, it has 2 front yards. And the front yard along Ober Road is the prevailing front yard setback, which is 47.1. The proposed setback is 20 feet. And they're also seeking a variance from the maximum driveway width at the property line, which is 10 feet, and they are seeking an 18-foot opening. And they're also requesting that the maximum driveway width at the curb road be 22 feet, where the maximum is permitted is 18 feet. And this exception is located in the public right-of-way, and as such, it would need approval from mayor and council. They're seeking consideration under the C2 criteria. And that's pretty much a short, brief examination of the memo. If you have any questions, I'd be glad to address them.
I have one. So we'll act first and then the council will act?
Yeah, I mean, I think it's appropriate that the board either say yes or no, and then if they say yes, then the applicant would go to the council, and they usually do a licensing agreement to allow for that larger exception into the street. So,
Okay, thank
yes,
you.
sir.
Mr. Dolphy, do you want to begin?
Sure, love to. Thank you, Mr. Chairman. Good evening, everybody. For the record, I'm Bob Rodolfi, the attorney for the applicants. First of all, I'd like to express my appreciation to Mr. Petrino for the courtesy and suggesting that we go first. We'll try to keep this short in view of that. As Derek has indicated, this is an application for 2 C2 variances and design waivers that would permit my clients to construct a new detached garage for their cars as well as their storage purposes. He's already described the depth and breadth of the variances, so I won't repeat those. The property is 174 Springdale Road. It's your lot 10 in block 10602. The property is located in your R5 residential zoning district. Before tonight's meeting, we've taken the time to review Derek's memorandum dated May 7th. And we have 3 witnesses, 4 actually, of the applicants, both David and Kimberly Bitterman. I'll start off with them. They'll describe their property, describe the proposed garage in the neighborhood. Next witness will be Bill Giddings. He's the architect who designed the garage. And I'll finish up with Jim Kyle, who you know is a professional planner. He will provide the justification for the board to consider approving the variances as requested.
Mr. Rodolphe, do you want to swear everyone in at this time and then you can present the testimony?
Yeah, I think that makes good sense, Karen.
All right, Mr. and Mrs. Bitterman, Mr. Giddings, and Mr. Kyle, do you swear affirm your testimony this evening will be truthful?
I do.
Thank you.
Okay, thank you. Okay, good evening, David and Kimberly. You are in fact the applicants for this presentation, correct?
Yes.
And you are familiar with the documents submitted on your behalf to the Zoning Board of Adjustment for the variances requested?
Yes.
And did you take the time to review Derek's memorandum?
Yes.
Okay. So you are the owners of 174 Springdale, correct?
Yes.
And when did you purchase the property?
August 13th, 2013.
Okay. And this is a single family dwelling, is it not?
Yes, it is.
Okay. And who resides in the house with the two of you?
It's the two of us, our 2 Labrador retrievers, and 3 grown sons that come back home frequently.
Okay. And you currently have no garage on the property or shelter for your vehicles or any outside lawn equipment, for example. Is that correct?
That is correct.
And where do you currently store things like your lawnmower, tools, bicycles, skateboards, all that good stuff?
Everything is stored in the basement of the inside of the house. So when we want to go for a bike ride or do anything, we carry it up the stairs and outside.
Do you have any outside storage whatsoever on the property?
We do not.
Okay. Do most of your neighbors have garages associated with their houses?
Yes.
Okay. So if you bought the house in, say, 2013, can I ask you why now apply for the garage since you've owned it since 2013?
Simple response is 3 college tuitions are just behind us, and now is a good time.
That's a pretty good answer. Thank you. Thank you, David. Have you taken the time after we filed the application on your behalf to discuss your plans and intentions with your neighbors?
Yes, I have.
And can you generally describe the reaction you got from your neighbors, if that's possible?
Yes, absolutely. Everybody was very supportive. I think they believe because we did not even tear down the house when we renovated it, they were just happy that we wanted to keep the old house. And when one neighbor remarked that she just hoped we didn't hide the house with the new garage because we did such a nice job on the house. So I think everybody's in support.
Okay, great.
It was very valuable to us.
Thank you. Claudia, would you mind putting up the photograph that I sent you so the board can have a better understanding of the area we're about to discuss?
Mr. Rodolphe, would you like this to be what, exhibit A1?
Call it A1.
Okay.
And once it's up, I'll ask either Kimberly or David to describe the exhibit. So we just have that for the record.
Okay.
There we go. Kim or Dave, would you just take a minute to describe the photograph that's on the screen now for the board's information?
Yes. So what you're looking at now is the Ober Road entrance. So it's actually the backyard of our home is to the left of where the cars are parked right now. And what we're proposing is to move that driveway directly to the right and put the garage there.
Okay, so just so the board understands, what's not shown in this photo, maybe with a later exhibit, your house fronts on Springdale, correct?
Yes,
Yes.
And those, we're looking at your backyard and your sort of side yard now, right?
Yes.
Okay. And that driveway apron is existing, and that was there before you bought the house, right?
Yes.
yes.
Okay. One question I'd like to ask right off the bat is, we'll talk about the proposed location for your garage in a second, but did you ever think about putting the garage in line with the existing driveway cut? Would that work?
It would eat up what little backyard we have right now.
Okay,
We would have nothing.
so your plan is to locate the garage to the right of those two automobiles, right?
Yes.
Okay, now, talk to me or talk to the board about that, what appears to be a fence or a wall covered with ivy or some kind of growth. What is that?
So that was existing when we purchased the house, and we just have never, it's a little actually unsightly and dilapidated. We've never taken it down because it does offer us a little bit of privacy in the back, and it's a barrier for the animals. But it's just an old wood fence, and it has a variety of, weeds and maybe some vinca growing on it. But it was there when we bought the house.
Okay, so your plan would be to install curb with existing driveway cut appears now in this photograph, and then have a new driveway entrance to the left of that, what appears to be a birch tree. I'm not sure what kind of tree it is. Is that accurate?
Yes.
And then the garage would be directly behind the fence and that large pine tree.
Yes,
Yes.
correct.
Okay. I think that's all I have of you at this point, but don't go away. I may have questions later on. Mr. Chairman, any questions from any members of the?
I don't have any questions. Do any other board members? Can you hear me right now?
Yes,
Yes.
I can hear you.
Okay, good.
Yep.
Yeah, any other board members have any questions of Mr. Rodolphe? Or the Bittermans? Okay.
I have a question. What will happen with those three mature trees that are to the right of your cars?
They would have to be removed.
I believe that one of the three is dead. I can't confirm that, but I believe there's one tree near the pine that's been overwhelmed by the pine.
They're both very tall trees. They looked healthy to me, but they did look close to each other. You can't actually see the one. I don't believe you can see the one that you're talking about from this. You would have to be like standing on Springdale to see it, right?
Yes.
Or in your backyard, which I didn't take the liberty of doing.
I think the one where you see it's kind of leggy behind the pine is, I believe that may be dead, but I can't confirm that.
It looked pretty leafy to me.
Okay.
They're close to each other. They're very close to each other. That's not the one we're talking about. I think that's farther away, isn't it?
Yes, that is in the back.
Oh, yeah, it is. I'm sorry. Yes, it is.
Dave, has the Princeton arborist been out to inspect the property and the trees?
Yes, he has.
And can you summarize your conversation with the arborist for the board?
The arborist met with Silverguard, Jack Scratcher, to look at the trees to be removed. And we're happy to plant trees or do whatever is necessary, because I know trees are precious.
Did he talk about how old he thought they were?
Not that I recall.
And just so the board understands, can you explain who Silverguard is, Kim?
Silverguard is a tree removal company that we've used for years, and the university uses. I'm sure you've seen their trucks around. They do a lot of commercial and residential work.
Okay, thank you.
Okay, maybe we can remove the photograph. Um, Any other board members want to comment at this time? Questions? Okay, Mr. Rudolphi, continue.
Okay, I'd like to bring on Bill Giddings now. Bill, you there?
Yes.
Okay, you've been sworn. I believe Mr. Giddings has testified numerous occasions before this board. I'd be happy to requalify him, Mr. Chairman, if you want me to.
I'm not, I don't remember Mr. Giddings. Why don't you just give me a brief synopsis here, your
Sure, Bill,
experience?
want to run through your quick employment and professional background, please?
Sure. I worked for Short and Ford in 1990, became licensed in about 93, 94. Started my own practice in 97. We do a lot of work for the university, a lot of residential work in Princeton and the Cranberry area.
Are you currently licensed?
Yes, licensed in New Jersey and Pennsylvania.
Okay, I mean, I would accept you as a qualified expert. Thank you.
Thank you, Mr. Chairman. Bill, the plans which were submitted in conjunction with this application were prepared by you, correct?
Yes.
And are you familiar with the premises in question and the general neighborhood surrounding the property?
Yes, I am.
Have you personally visited the site?
Yes.
And have you familiarized yourself with Princeton's land development ordinance and its master plan?
Yes.
All right. Did you take all of the above, the ordinance and the master plan and the zoning ordinance, into consideration in formulating your design for the proposed garage?
Yes.
Okay. Maybe now it's time for us to get your elevations up on the screen. You could do that, Claudia? There we go.
Rodolphe, you'd like this to be Exhibit A2?
A2 would be great, thank you.
Okay.
Right, Karen. Bill, would you please identify what's just been marked as A2?
Yes. So I think first I'd like to point out on detail two on the drawing, which is the tax map, the lot 10, which is hatched. You can see this lot is considerably, lot 10 and 11, they're two smaller lots in comparison to all the other surrounding lots and the corner lot. So that presented challenges in terms of locating the garage, how to best locate the garage, but also preserve some type of rear yard for the house. So we pushed the garage as far as we could to the east and set back the garage proposed 20 feet from the property line. Property line is quite a distance. It's approximately a little over 12, around 12.6 from the curb line. In order to enable parking outside of the garage as well as inside of the garage, since they have adult children who drive. If you notice, the existing house is only set back 15.4 feet from the property line. So the proposed garage is set back an additional 5.5 feet from the existing house. And so we really try to make it as compact as possible to get as much parking off the street. And then also to give just enough room to have a little bit of storage in the back. So the garage is 23 feet wide in order to park 2 cars inside. We made it a little bit deeper, the 24 feet, so that there's room in the back for bicycles, lawnmowers, yard equipment, but still a pretty modest garage.
And it's a one-story garage, right?
Correct.
Okay. Can you talk to the board about the building materials? What color will the garage be?
So the garage will be stucco with wood trim eaves, probably made out of painted boral to mimic the wood of the original house.
And
so it's the same detailing as the original house.
okay, and roofing material, Bill?
Just shingles.
Okay. And can you talk about the fenestration, proposed fenestration? You may want to switch to your elevations now.
Yeah, so you want to go to the fourth drawing in the set. So on the top elevation is the elevation of which faces the back of the house. So it's two windows with shutters similar to the house, with a door and a copper roof. In order to maintain more of a carriage style garage, not a modern garage, but something that's more in keeping with the age and circa of the main house. The other two elevations are pretty straightforward. Minimal fenestration. There's landscaping. So the southwest elevation really is not visible because of the existing screening to remain between the properties. And the detail 2, the southeast elevation, which faces their own backyard, just has a window up high to give some relief to the facade. But because of that's really the storage wall in the garage, it's solid. The northwest elevation on Ober Road, detail 4, that is the facade that will face the street, doing a carriage style garage door so that again it fits with the circa of the main house. A base that steps out, again mimicking the main house, with small cornice and eaves similar to the main house. And the gable is turned in order to maintain all height to setback ratios from property lines.
Now, the doors which appear on your northwest elevation, there's fenestration above the wooden doors, right?
Yes.
Okay. And then it appears that there's a window in the apex, if that's the correct term, of that elevation above the 4 garage doors.
Yes.
Is there storage? Is there planned storage above the automobile space in the garage, or is that just faux space?
It could be used for storage. It will be an attic space, so it could be used for storage as well.
Okay.
Downstairs.
All right. I think I described it as a one-story garage. I may have misspoken. When I saw this, I said, "Oh, looks like there's space above the storage area in the garage."
You won't have. It won't be a stand-up room. You know.
It would not be living space.
Right. You wouldn't be able to stand it. It's a space where you would basically have to put a ladder up or a pull-down stair and kind of crawl into it to put boxes, that you don't access very often.
All right. And it's your testimony that the building materials and the outside appearance of the proposed garage will be very strikingly similar to that of the main house.
Yes.
All right. Can you tell us that you exerted your best efforts to design the proposed garage in conformance with the zoning ordinance, but were frankly unable to do it?
Yes. If we go back to the first drawing. Garden Makers has done a nice job on this landscape, proposed landscape, to try to make a little bit of a grass area behind the garage. That really is their backyard for their dogs. For future homeowners, that would be the backyard for younger children. So if we maintained the prevailing setback, garage would be smack into that area, sort of the only green area rear of the house. So that is why we are requesting the variance, to maintain some backyard, but also get the maximum off-street parking.
Now, you're familiar with the neighborhood of this property, right? Oops, where'd you go? Bill, you still there?
Hmm. Where'd he go?
I don't know.
Huh.
I still don't see him.
I'm going to mention at this moment that Steve Cohen, our chair, has dropped out because there's some bad weather problems where he is. It shouldn't be affecting anybody other than him because he's in Wyoming, but I'm just saying. I'm gonna take over. I'm just trying to use our time efficiently while we're waiting to see what happened to your expert, so.
Should we move on to our planner, and if Bill
Sure.
comes back again, we can continue his test. So I don't want to hold up the board. Jim, you there? Jim Kyle?
I'm here.
There he
There
is.
you go. Good. Okay. You're not in Wyoming, are you?
I'm not. I'm in Hopewell, unfortunately, but
Okay. Jim, you've been sworn, and Eve,
oh, Bill's back.
Yeah, I thought I heard a ding, so I figured he was back. Bill, are you there?
You're on mute.
There he is.
there he is. Bill, can you hear us now?
Yes, sorry.
Okay, good. I just have one or two more questions, and I'll finish up with you, subject to the board's questions, of course. You're familiar with the neighborhood, Ober Road and the area, correct?
Yes.
Is it your testimony that this proposed garage, as it relates to the house, is fairly consistent with the other residences in the immediate neighborhood?
Yes, if you look at the detail 4 on the first sheet and the setbacks, the other corner house across from the street has about a 17, a little bit over a 17-foot setback. So, you know, both of these houses create sort of a bookend to the street. And then after these houses, the setbacks are similar in terms of the prevailing wage to each other. So,
Okay. I have no further questions. Madam Chair?
Does anyone on the board have any questions at this point? Okay.
Okay, let's go back to Mr. Kyle. Jim, you still with us?
I am.
Okay, good. You've testified before this board on numerous occasions previously, right?
Many times.
All right. Madam Chair, should I go through his credentials for the benefit of the board? Or are you familiar with his?
I think we're familiar. It may be a sentence or two, but I think he's a familiar face to me, and well, yeah.
Okay, Jim,
I think we're fine.
A quick resume, just your educational and professional background, just so the board's comfortable.
Sure. I have a Bachelor of Science in Environmental Planning and Design from Rutgers. I'm licensed by the state of New Jersey as a professional planner. I've been qualified by over probably 230 boards in the state, including numerous appearances here before the zoning board.
Thank you, Mr. Kyle.
Sure.
Thanks, Jim. Yeah, you are familiar with the application materials submitted on behalf of the Bittermans, correct?
I am.
And you're familiar with the site and the neighborhood?
Yes.
And have you personally visited this site
I have.
previously tonight? Okay.
Yep.
And you're familiar with with Princeton's land development ordinance as well as its master plan?
I am.
And you've taken the time to review the zoning officer's memorandum summarizing the essence of this application?
I have.
Okay. Are you able to provide the planning rationale that would enable this board to approve the variances as requested? And if so, would you please describe what your investigation revealed?
Sure. So as Mr. Bridger had pointed out, this is an undersized lot for the R5 district. 21,780 is required. 15,309 is what exists. As Mr. Giddings had pointed out, this and the lot next door to us, 11, are kind of the two smaller lots. You can see to the north of us, some of those lots are a little deeper and a little bigger. So that did create some challenges. Another nonconformity that we have here, as Mr. Giddings had identified, as well as Mr. Bridger, is the existing front yard setback of the house. It's about 15.4 feet from over road and 25 is required. So really, I think, as Mr. Bridger noted, we're going to address these variances under the C2 criteria, where their purposes of zoning are promoted by the grant of the variance and the benefits outweigh the detriments. So let's first talk about the front yard setback. As we talked about, the prevailing setback is what's required here. And based on the measurements that Mr. Giddings had done and we had gone through with Mr. Bridger, 47 feet 10 inches is what's required, and we're proposing 20. So in terms of the positive criteria on the C2, I think that the grant of the variance here promotes purpose A, the general welfare, as well as purpose I, a desirable visual environment. So situating the garage in the manner that we're proposing and reducing the front yard setback, as the Bittermans had discussed, really ensures that there's adequate usable yard area provided. This is a corner lot on 2 streets. So if we were to push that garage, as Mr. Giddings had described, to the 47 feet, we would essentially consume a pretty good portion of that rear yard, and it would really eliminate a lot of that useful space there. The combination of the required setback and the depth of the garage is really what reduces the open yard area if we were to provide a conforming setback. So the other benefit here is that locating the garage closer to the street, to Ober Road, actually gives us more consistency with the setback of the existing dwellings. Mr. Giddings had said we're actually going to provide an extra 5 feet from the 15.4 that's provided there. So visually, it provides a little more consistent appearance from Ober Road. The other benefit here is that putting that garage closer to the street allows us to greatly reduce the length of the driveway. We can shorten it up considerably to what's proposed, as opposed to, imagine a garage that's 47 feet from the street. We would need that single width drive and then widen out to the 2 driveway spaces there. So there'd be considerably more impervious coverage that would have to be put on this lot in order to comply with that. And I would note, per the architectural plans, right now we are at, zoom in here so I can see this. With this proposal, we'll be at 29.56%, and 30% is what's permitted in the zone district. So in all reality, probably what we would do in a conforming location is then require a coverage variance. So it's really offsetting that need, greatly reducing the impervious coverage, which I think is a benefit here. So there's really a twofold benefit in that regard. In terms of the negative criteria, I think the departure that we're seeking here will not substantially impact surrounding properties. As Mr. Giddings had testified, it's relatively consistent with other garage conditions that you see in terms of setbacks on the street. There's also a pretty substantial buffer between the adjacent property where the garage would be located in the side yard, and that's immediately to the west, that is going to be maintained. So in terms of any visual impact of the garage, and you also saw in the architectural plans, there's a pretty robust landscape plan that is proposed. So what we'll have is screening along the western side, and then along Ober Road, there's also proposed to be some additional landscaping installed there to provide some privacy, which will also screen the view of the garage. So really, as you drive along Ober Road, you're gonna have a fairly small window of view of this garage. So I think based on that, the potential visual impact should be fairly limited in that regard. And I think given that we can provide that adequate screening, I don't think this departure will have a substantial impact on the intent. I don't want to say it's a unique situation with a corner lot, but when you look at the size of this lot versus others immediately surrounding in the same zone district, it does create some challenges as we talked about. But I think the fact that we can mitigate the appearance of the garage or the reduced setback with landscaping, I think the benefits of the reduced impervious coverage in particular here far outweigh any of those potential detriments, and the board could grant the relief that's requested. As far as the driveway width at the property line, as Mr. Bridger noted, 10 feet is the maximum permitted, and we're proposing 18. And then the width of the curb at the face, 14 feet is permitted, and we're proposing 22. I think the argument here is really similar on a C2 analysis, purposes A and I. Again, placing the garage in a manner that would allow for conformance with the width requirements would increase the amount of impervious coverage that would be required to achieve those requirements. So overall, this configuration really results in less impervious coverage overall on the property. And we think that there's a general welfare benefit there, and it will also improve the appearance of the property by reducing the amount of coverage on the lot as well. In terms of the negative, I don't think the increased driveway width will cause substantial impact to surrounding properties. Again, we're going to have fairly significant buffering on either side of the driveway and on either side of the garage. So it's really going to shorten that window of view of that wider driveway. And overall, again, this approach really allows us to effectively reduce that coverage. We can provide a double width really immediately just in front of the garage. And the benefit here is, again, that we're going to reduce that impervious coverage. So I think based on that, there won't be any substantial impairment to the intent of those standards. Really is the departure that we're seeking here is a better zoning alternative given the configuration of this corner lot and the existing structure that we have in that setback. And again, we're going to achieve a more consistent appearance here. So I think, again, with this one, the benefits of granting this relief substantially outweigh any potential detriments in terms of visual impact.
Yeah, we have another exhibit. Would it be instructional for the board to look at that and you discuss it, or?
I think so. Does Claudia have that?
Yeah, I sent that to Claudia.
Which one is that?
It's the last one I sent you. I forget what it's labeled, but it's it shows where the garage is proposed versus where it could have gone per the zoning ordinance. It's pretty instructional. That's why I wanted to show it.
Could I ask while we're waiting, do I remember correctly, because I didn't print everything out because I didn't want to have a big stack, but the driveway is not as wide as the curb cut, right? It's not, it's 22 at the street, but it's narrower in the actual driveway, or am I wrong about that?
You're correct. It's 18 feet is the actual width of the driveway, whereas the curb cut is 22 feet. And that's just to allow adequate radius for the cars to turn in off of Ober Road, which is a fairly narrow street. So just widening it out at the curb to just provide additional radius for the cars to be able to turn in, particularly if there's another car in the driveway. So it just helps with accessibility.
Okay. Thank you. We're waiting for Claudia to put up the, right.
I actually have it here, Claudia. If you want me to just share the screen, I can do that.
That will be great.
Okay.
Thanks, Jim.
So this will be exhibit A3?
Yes.
Okay.
There we go.
So this is A3 is an exhibit that Mr. Giddings prepared. It shows where the red box is where the garage would be located if it were in a conforming setback of 47 feet 10 inches. And then what he showed here was a conforming width of the driveway opening, and then the first section of driveway then widening out to the 18 feet width that would be required to access both sides of the garage door. So, excuse me, both sides of the garage. So you can see pretty clearly, I think, from this exhibit, one, that it would really consume that open area, not really leave a whole lot of usable yard area here. But more importantly, it would require a significantly increased amount of impervious coverage in the form of driveway in order to access that garage.
Okay. All right, thanks, Jim. I think that's pretty instructional. Thank you.
Sure.
I have no further testimony from Mr. Cloud nor any of the other folks tonight. Madam Chair, or Steve, if you're back again.
I think it's me from now on, so
Okay.
I'll do my best.
Thank you, Madam Chair.
So, oh, wait,
Steve's here. Can
No,
you
no.
hear us, Steve? Okay.
no?
I missed a part of the hearing, so I'd rather Eve finish this one.
Okay.
Okay. So, does anybody on the board have any questions at this time for the experts before we open it to possibility of public comment?
Yeah, I have
I
a
do.
question.
Go ahead.
Okay. So the drawing that you were just showing that showed the narrower apron, I understand, that's because the garage was pushed farther back, but could it be reduced with the garage in the current place if after you reach the car length, it narrows down a bit? It does seem like a 22-foot apron in a 10-foot in an area that they're supposed to be, or 14 feet is fairly wide.
Bill, could you address that perhaps?
Sure. So when you're pulling out of the car, unfortunately, you have to pull directly out. You can't start turning, otherwise you could flip the door with the front end. So you've got to really pull out entirely.
Right.
And then if you turned, you'd have to cut the wheel, immediately once you got out of the garage in order to, I think, to make the apron smaller. Well, let me rephrase that. So if you're just looking to make the apron the 18 feet rather than 22 feet, is that the question?
Just, yeah, trying to reduce that apron a bit. I recognize that there's not, you're not going to take a lot out of it, but could it be reduced?
The apron is really kind of utilizes the ordinance standards in terms of providing a 2-foot length to transition the granite curbs from a 6-inch high down to a 0 cut. So it also allows the wheel to go over by mistake, but it's not so much. I don't know if you still have. You can see it in the original picture, I believe, of the existing driveway. It just gives you that transitional area. Overlane probably is wide enough that you could make it smaller in terms of the turning radius turning in, but 2 feet really is not much. And if there's cars parked on over, it would be difficult to get in there. Also, the 18 feet wide that we're proposing is pretty narrow for 2 cars. I would have rather had 20 feet, but we were trying to make it as tight as possible. So by not providing that 2-foot flare, it's making something that's already pretty minimal more difficult. So I would not recommend it.
Okay.
Yeah, there, Donna, did you want to speak?
Yeah. Thanks, Steve. Your existing driveway versus the new driveway. The existing driveway would be completely lawned or
Donna, you're kind of
plantings,
cutting out.
or
Yes.
is it no longer going to be coverage?
Yes. So
it won't be impervious coverage.
So the existing driveway would be, stones would be removed. The curb would be replaced. the transition would be grass, and where the existing stones are within the property line would be made into landscaped with grass and bushes and shrubs, as shown on the landscape plan.
Oh, I think
Okay,
she's,
and
think
that
she's
would
frozen.
be replaced by the new driveway. So do you have a net increase or decrease of impervious coverage there?
It's not.
Were you able to get that question? I wonder,
Yes, I understand the question.
okay, could you repeat it then for us?
Sure. She's asking that the total area of the existing driveway versus the total area of the new driveway. So I can quickly try to calculate that. My estimate is that it's the same. The new driveway is the same or less, because the old driveway was much deeper. But I can do a quick calculation on the computer if you want to go to another question.
And by deeper, you mean longer, farther into the property?
Yes.
Anyone else have any questions? On the board, that is? Should we, so I guess what we want to do, I guess we'll wait for a second for you to,
Okay.
unless that's too much pressure, we could, are there, shall we see if there is anyone in the public who would like to speak? If you do, unmute yourself or raise your hand with the little icon. I don't see anybody.
I don't see anybody either. No hands.
Okay. Donna, were you finished with your questioning?
Yes.
Okay.
I'm looking at the plans the applicant submitted, and the existing impervious coverage is 24.76 and the proposed is 29.56. So it goes up a little less than 5%.
And that's because of the garage in addition to the driveway. I was commenting just on the driveway area, not the addition of the garage. That's the differential.
Got it. Thank you.
So,
No, you were here, you scared me. Why you work so late?
so Mr. Rodolfi, do you have anything else you'd like to say before we go into executive
No, I
session?
think we presented our case thoroughly, and I just rely on the testimony from the applicants and the two consultants. Thank you.
And just to answer that question, the existing stone area of the driveway is about 790 square feet. The new driveway is approximately 600 square feet.
Thanks.
Thank you. Okay, I guess we'll go into executive session now. I'd like to hear what my fellow board members think before we go into a vote.
I think it looks like a well thought out plan, and I would vote to approve it.
Okay. Anyone else? I will say that I always worry about mature trees being taken down, and in every other way, I feel like the plan makes a lot of sense. I understand what the reasoning is, and it's probably I feel like they've taken a lot of other important things into account. It's a shame when we have to lose big trees. And I see that you have a pretty good landscaping plan. They're never, it'll take a while for them to catch up to the ones you have. And really it's that one pine tree or evergreen, I'm not exactly sure. That one looks, I don't even know how to estimate how tall it is. I mean, it's a big one, so. It sounds like you thought about that too, but I don't know what else you can do if you want to. And I'm happy that you're minimizing impervious coverage as much as possible.
I definitely appreciate the comment, and we also like a wooded sort of warm feeling. So the effort was to minimize, taking down anything that was alive.
Anybody else, or should we, if they're hearing no other comments, would someone like to make a motion? Am I skipping anything, Karen? Are we in good shape?
You're good. You're
Okay.
good.
I move we approve the motion or the resolution.
Do I have a second? Was that George?
Yes, it was George.
George Stein, second.
Okay. Claudia, can you call for a vote?
Okay. Ms. Coulson,
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Ms. Chen,
Yes.
Mr. Stein,
Yes.
Anna.
Yes.
Do we have Mr. Cohen here? No.
Yeah, I'm here, but I missed a part
Okay.
due to a technical difficulty, so I'm going to abstain from the vote.
Okay. Thank you. Approved.
Thank you very much, everybody.
Thanks, everybody.
Thank you very much.
Have a good evening.
Have a good
You
evening.
too.
Eve, can I ask you to start to read the next one and I'll continue on, if that's okay?
Are we, do we have who we need? We're going back to Lambert Drive. We started that one and I'll but do we have the, someone was missing one of the test.
Yes, hi, this is Frank Petrino again. Mr. Falcone is with us.
Oh, good. Okay, so just to review, we're going to be talking about 270 Lambert Drive, block 8101, lot 22 in the R1 zone, and it's case Z20-920.
Thank you, Eve.
Sure.
I appreciate it. I'm sorry for the inconvenience, folks. I have a computer issue here this evening. Derek, can you read your memo on this or summarize it, please? Oh, first, excuse me, Karen, are the notices in order?
It is. They are, and the board has jurisdiction tonight.
Thank you. Derek? You're muted, Derek.
Excuse me. Thank you, Chairman Cohen. Ben and Dana Weiss are the owners of 270 Lambert Drive. They are seeking a C1 hardship variance to permit the approval of a previously constructed deck in exception to the required side yard setback and maximum impervious coverage. Property is located in the R1 zone in the former Princeton Township. Subject lot is non-complying with respect to the required 87,120 square feet. The existing lot is 72,320 square feet. And the subject property is non-complying with respect to the maximum impervious coverage ratio of 19.5%. The existing is 21.26. Subject property received a lot area variance in 2012 to permit demolition of an existing house and construction of the new current house. A notice of violation was issued in August of 2020 for constructing a 512 square foot deck without zoning approval. Summons to appear in court was issued in November. The applicant submitted a variance application for the deck in December, and the court has tabled any legal action while this case processes through the zoning board hearing process. The applicant is seeking two approvals for the deck. They need a variance for the required 15-foot side yard setback. The proposed is 9.3 feet, and the impervious coverage increases from 21.26 to 21.97, whereas the maximum is 19.5. The applicant is proposing to limit the variance in the presence of the deck to their period of ownership. The deck is to be removed upon transfer of title. If they are proposing a deed restriction and other conditions that they will discuss at the hearing. If you have any questions, that's a short synopsis of the case. Thank you.
Okay, thank you.
Yep.
Mr. Petrino.
Thank you. Good evening. My name is Frank Petrino. I'm with the law firm of Eckert Siemens. We represent the applicants, Ben and Dana Weiss. Just a couple of comments on the memo that was just read into the record. We are seeking C2 or flexible C variances for both these variances. And as to the side yard setback, the encroachment at one point is is into the setback approximately 10 feet, but approximately 56% or 60% of the deck is not located within the setback. It's only approximately 40%. As to the coverage variance, we already have legally permitted coverage of 21.26%. We are seeking to increase that to 21.93%. That's with the addition of the deck, and the deck is 512 square feet. So that's why the increase in coverage is less than 0.75%. It's for want of a better term, a de minimis increase. We have, we'll take you through our proofs. Mr. Falcone will take you through the proofs. We think we clearly and easily satisfy the criteria, both negative and positive, for the granting of C2 variances. And again, we will take you through that testimony, but notwithstanding, we think that both of these could be granted and they could be permanent. We have agreed with our neighbor, who is located closest to the deck, that when the property is sold, the deck would be removed prior to the closing of title. Now, in terms of durational conditions to variances, I think unlike D variances where it's somewhat unusual, with C variants, it's not as unusual. They just have to be carefully crafted by the board and the applicant so that they are enforceable and can and will be satisfied. Diane, are you on? Can you put photo 2 up? Diane?
Diane Schaefer is muted if you need her to answer you.
Trying to get it up. Answer if she, Diane, can you put up the
there it is.
Photo 2? Okay,
Yep.
Thank you. Okay. You'll hear more about this, but this is the deck. And what I want to point out in particular is the fact that the deck has no roof. We have built the deck to avoid removing mature trees. And those, when the deck is removed, those trees will remain. You can also see, and we'll show you on the on a plan, you can see a 6-foot deck that's on the property line. That deck is also on the property line that fronts on the road. That 6-foot deck effectively obscures the view of this deck. You can't see it from the road. You can't see it from the other property unless you're in the second floor of that property and looking down. Car driving by, your head is at the height of approximately 3 feet, 3.5 feet. So that deck is not visible. I think great pains were taken to maintain the open space of this lot, and you'll see that, and Mr. Frank Falcone will explain that to you. So great pains were taken to preserve the trees and preserve the open space within the lot. So we have 3 witnesses. Our first witness is one of the applicants, Ben Weiss, and he'll talk to you about when the deck was constructed, the circumstances around that, and how the location was chosen. Our second witness is Frank Falcone, our planning expert, and he'll take you through the planning testimony and provide the proofs for the requested variances. And we have a neighbor who is expected to call in, Mr. Gregory Evans. He's the adjoining property. He's the owner of the house you see behind the fence. He has no objection to the deck remaining in place, but it asked, and the applicant agreed, that when it sells the house, it will remove the deck. So unless you have questions for me, I'd ask Mr. Weiss to raise his hand and we can take him through his testimony.
Mr. Petrino, question, can you take this down so we can see Mr. Weiss? Great.
Oh, sure.
Okay, Mr. Weiss, I don't know where you are, but
Raise your hand.
there you are. Okay, do you swear affirm your testimony this evening will be truthful?
Yes.
Thank you.
He's the better looking Frank.
Oh.
Anyway, so Mr. Weiss, where do you reside?
270 Lambert, Princeton.
And who resides in that residence with you?
My wife, Dana, my daughter, Shayna, and my son, Jack, who is now in college. By the way, 2 Hun graduates, so I was very happy to see that you were able to get that passed earlier tonight.
And what is your occupation?
I am the founder of a beverage company that's located in Hamilton, New Jersey, called Crook and Marker.
And that Hamilton is Hamilton Township, Mercer County.
Correct.
Thank you. So rather than me do a Q&A with you, and why don't you tell us about or advise the board when the deck was constructed, how the location was chosen, and just go through the background of the construction of the deck.
Sure. So it was constructed in the early months of COVID quarantine about a year ago. And as we all know, at that point in time, the confines of our house made backyards somewhat of a safe haven, and we took to our backyard. We're very fortunate to have a beautiful backyard. And that particular location was selected because of that picture showed there are these 4 beautiful trees that are very mature and have the great canopy. They offer a great canopy and respite from the sun. It's otherwise very sunny backyard. And we've used that throughout the years that we've been here. In fact, my daughter, Shane, and I would roast s'mores in that little corner, which didn't have obviously anything formal there. So we took the opportunity to kind of formalize that space, not just to really take advantage of, like I said, the canopy, but also the view. So it allows me to kind of keep a watchful eye on my family and my kids' friends as they swim in the pool without being right on top of them. So it's kind of a place that, a little spot, a little corner of our property that we've kind of grown up appreciating.
And how old is your daughter?
So she is now a sophomore in HUD. So that'll make it 15.
Thank you.
15.
And you've had conversations with your neighbor about the
Yeah.
deck, and what has he said to you about?
So I think it's important to mention, I actually have a very good relationship with Greg Evans. We, I brought him in and said, hey, listen, this is a space that, like I mentioned, kind of plays a role in our lives. When it was determined that, not knowingly, we were beyond the setback, he was obviously my first call, and we had a great conversation. He had no issues with it. I put up some trees to shade it. I think it shows that in the picture. And his only one request was that, basically, hey, Ben, I trust you. I have no issue with you. But if you sell the house and somebody comes in there and that becomes a stage for a band to play there or something, that's a problem. And mind you, I might have been on that, deck, 3 times in the last, 4 months, because we've been traveling a lot. So it doesn't get a lot of use, and it certainly doesn't impose upon him. And I said, to alleviate that concern, if I ever sell this house, which I have no intent to, we love living in Princeton. We've been here for 15 years. But if I ever did, I would take it down.
Okay. Thank you, Mr. Weiss. I have no further questions for Mr. Weiss.
Do you have any other witnesses?
Yes, 2 other witnesses. No questions for Mr. Weiss?
I don't have any. Any board
Okay.
members' questions? Okay, please
Okay,
continue.
then I'd ask that Frank Falcone be sworn in.
Mr. Falcone, do you swear affirm your testimony this evening will be truthful?
I do.
Thank you.
All right, Frank, let me ask you a couple of preliminary questions. By whom were you employed and in what capacity?
I am a Associate Director of Princeton Junction Engineering.
Okay, and what is your educational background and what licenses do you hold in New Jersey, and are they
Excuse me, I think we
currently
can,
valid?
Mr. Falcone has testified before us many, many times, so we would accept him as an expert.
Okay, we're offering as an expert in planning. He is a licensed planner as well as holding other licenses in New Jersey.
Yes, he's testified before us. That's fine.
Okay, just a couple of things. Just these things are on the website and were available for people to review. And I just want to confirm that, Frank, you either prepared or supervised the preparation of the plan entitled Pool Frame Location Survey dated September 25, 2020.
That is correct, and I've been associated with the construction on this property since the original house was demolished. And I presented the lot size variance application back in 2012. We also designed the pool area, and we did prepare the plan you just mentioned.
Mr. Petrino, do you want this to be an exhibit? Is it going to be up on the screen, or?
Now, what is going to be up on the screen is a portion of what I'm going to identify next.
Okay, okay.
What, again, Frank, did you prepare or supervise the preparation of the variance request plan dated February 22, 2021? And I believe that's a total of 3 sheets.
Yes, I did.
Okay. Now I'm going to ask Diane Schaefer to put up sheet 3 of the variance request plan set.
And you want that marked as an exhibit, Mr. Petrino?
Yeah, I mean, if that's your practice,
is.
I mean,
It is.
typically some boards, if it's part of the material that's on file, they don't. But if you want to mark this exhibit A2, we probably should have marked the photograph exhibit A1, but whatever your pleasure is, Karen.
Okay, that's fine. Are you going to go back to the photo or?
Yeah, I think we can go back and forth through it.
Okay,
As
all right. So
Frank,
that's A1 and this one is A2. Okay, thank you.
okay, and Frank can decide which one he wants to refer to when he's providing his expert testimony. So Frank, we have you and I have talked about the project history, about the current state of the property and how it came to be that this deck was constructed. So again, rather than a Q&A, can you take us through your both factual and opinion as to those reasons that support the granting of a C2 variance for both of the required and requested variances?
Yes, obviously this subject of this application is the deck located in the southeast portion of the property. It is currently 9.3 feet off of the left side yard setback.
Is the cursor on it now?
I don't see it. I have my cursor, but you probably can't see that.
All right. Diane, if you have a cursor, can you, yes, over to here?
Yeah.
Oh,
over
to the left, to the left.
deck
Yeah,
itself.
right there.
There's the deck. It's 9.3 feet off of the left, I'll call it the left side yard. It is behind the front setback. It is located in a grove of trees, and there's really not many trees on the site except on the perimeter. So I could understand why Mr. Weiss wanted to locate this deck within that area. The rest of the lot is open. You see the pool and the pergola along the south property line. On the north property line is a detached garage, and there are some trees there, but primarily the entire site is open. You described the fence that's along basically the front setback line and then the southerly property line. It's a 6-foot PVC fence, solid fence. There's a lot of landscaping the Weisses have installed in the form of shrubs along the fence. So it's very well screened from the front yard setback and the south side yard.
Frank, can I stop you for 1 second? If we could put the prior exhibit, Diane, just to reinforce Frank's testimony. Diane. Photo 2. Hello. I love technology. It's one of my favorite things.
There we go.
Okay.
Yeah, in this photo, you can see that south property line with the solid PVC fence. It's 6 foot high. There's shrubbery planted in front of it. There's arborvitaes planted along the front setback line behind the fence. There's very thick hedges that were planted and have become mature since 2013.
Diane, can you put up photo 3 as well? Because it demonstrates what Frank is talking about in terms of open space.
And then that'll be exhibit A3?
Correct.
Okay.
Okay, this is sitting on the deck with your back to Lambert Drive, looking to the west out over the pool area. Mr. Weiss testified that he can observe his children and their friends at the pool while he sits on the deck.
Okay.
But you can see it's very open with the majority of the vegetation on the property lines.
On the opposite property line.
Right, pretty much around the whole perimeter, but that's
Right.
really the only place where there's trees and shade.
Okay, I'll be quiet again. I'll let you continue.
Well, I guess, you know, a lot of the testimony that I had prepared has already been given. I agree with it. I think we can get right to the heart of the, what I'm considering are C2 variances. I would testify that the granting of the setback variance advances the municipal land use law of maintaining a lot's open space and preserving the natural mature trees, which it's very obvious that a lot of painstaking construction went in to this deck at the same time preserving these cedar trees. I think the variances can be granted without substantial detriment to the public good. The neighbor most impacted by the structure, to my knowledge, has no objections and was supposed to appear here tonight, Mr. Evans. I think the granting of the variances substantially outweigh any detriments, especially with the restriction that he would remove this deck upon the sale of this property. So that would not allow future owners to perhaps use this deck in a different manner than the Weisses are. I also believe that granting the variances will not substantially impair the intent and purpose of the zone plan or any zoning ordinances. I believe that the increase in impervious area is de minimis. You could almost say this deck is somewhat semi-pervious. You can see the center ring there has gravel in it, so most of the what would run off onto the ground and not into any storm system or anything like that. So I really feel that there's really not a detrimental impact to the neighbors or anybody else.
Anything further, Mr. Falcone?
No, that's about it. Unless members of the board have questions, I'll be happy to answer.
Well, before that, Mr. Chairman, I just want to reemphasize that the increase in the, and Mr. Falcone can confirm this, the increase in the amount of coverage is really limited to the size of the deck, which is 512 square feet. And it takes the coverage from what is currently permitted today on this lot as a result of prior actions by this board. Coverage of 21.26 is the legal permitted coverage today. And we're asking you to go to 21.97%. Or an increase of 0.1%. And again, that increase is simply the 512 square foot deck. Although this is not a D2 variance, D2 being an expansion of non-conforming uses, under the case law for expansion of non-conforming uses, there's a concept of de minimis. And if the expansion is de minimis, the courts have held that the D2 variance is not required. I only mention that by analogy. This clearly is a very minor or de minimis increase in the square footage and coverage of the lot. So I have nothing further. If anyone has questions for Mr. Falcone, he's available to answer them.
I have a question. Mr. Falcone, how did you happen to let Mr. Weiss and this family build about half the deck in the side yard setback?
I was totally unaware that they built the deck. I only came in after the fact when the violation was given to the Weisses, and they contacted me, and I located the deck and verified that it was indeed over the side yard setback.
I misunderstood, because I heard you say that you had been involved with, I thought I heard you say you'd been involved with the construction of the house and
the house and the pool,
I thought
but not the deck.
So I don't know who, I guess we don't know who let that happen.
Well, I think there's an explanation, and Mr. Weiss might be able to provide some information on that.
On who gave permission to do the deck?
No, on how this occurred
How did you, how
without
did
a
the deck
permit.
slip into the side yard setback by half?
Yeah, the question is, how did this get built without a permit? I think that's the question. And
Well,
and Mr. Weiss may be able to respond to that.
Well, I mean, it's a simple answer. I did not know I needed a permit to do it, to be honest.
So,
who, but somebody, usually the professionals know these things. that you work with.
Mr. Weiss, did you have at your business, did you have a person who did construction work for you, either at your office, at the warehouses, wherever? Is that the person who constructed it?
Yes. That's
Yeah. And you told him what you wanted, and he went out and did it, and you weren't involved in the issue of whether a permit was needed, not needed. He's a design, I mean, he's an experienced craftsman, and so it was never a topic of discussion between you and him. At least that's what I believe is the case.
That's correct.
Okay. So, Mr. Chairman, I mean, once we learned that this had occurred, the summons was issued. I got in contact with Mr. Bridger. I said that we would apply for the variance, and as a result of applying, the municipal court action was carried or delayed until after this board could decide whether we meet the proofs for the required variances. My position is, if the deck wasn't built and we came in today and said, this is where we want to build it, we've just demonstrated that we meet the requirements for the issuance of a C2 variance for both coverage and violating the sideline. And again, 60% of the structure, basically 60% of the structure is not in violation. It's a portion, and all the other factors that we talked about, including the fence and the landscaping. And Mr. Falcone has rendered an opinion that we meet all the negative and positive criteria for the granting of a C2 variance. So I think that's a long-winded answer to the question that was raised.
I agree.
Agree it's long-winded?
Yes.
I guess I get,
Can I ask?
go ahead, George, please.
Yeah. All right. So if we grant this ordinance, what happens to that municipal summons? Are there no consequences for building without a permit? Other than the fact they've had to hire a lot of planners and lawyers and so forth and come before the zoning board.
Well, that's up to, I guess, Mr. Bridger and the municipal court judge, but my position is if the variance is granted, the municipal court action should be dismissed. We're not running away from this issue. We're explaining to you what happened and when it happened. It happened during COVID. And we have, if we came in today to build it, we've satisfied the proofs for the granting of both variances.
I don't necessarily, go ahead, Michael, please.
Okay. I just want to confirm, this seems like this will be an area of not a lot of activity. I believe when I was out there, I saw, like, this won't be a barbecue area, because I think I saw grills right by the house itself. So you have another area where you're that type of activity. So I just want to confirm, nobody talked about that on, we talked about the pool. But is that, am I remembering correctly?
Yeah, if you're asking me, yes, Mike.
Yeah.
It was simply an attempt to more formalize a space
Yeah.
that I was using in a very intimate way. And, there was nothing that went on there other than respite from sun and just family gatherings. And, it's not set up to do anything other than that.
And s'mores.
So how do you cook the s'mores though, then?
Now, Donna,
How do
would
we
you like
cook the
fire? I don't
s'mores
know.
on how do we cook the s'mores? What?
I think that was in reference to how we were using it prior. So before all that, when it was just an empty space, we used to have a little fire pit there.
So the circular gravel pit is just for aesthetics, it's just pretty?
Well, it's for drainage as well.
Okay.
I
couldn't see it from.
I don't.
Please,
The use of, like I said, the use of the space is for family gatherings. And I think what has gone really untold is that our neighbor has agreed in writing that this would be an interference to him. And I think after almost a year, you could attest to the fact that there's not been anything there done that was ever intrusive on his property.
Right, but he doesn't speak for the people who might buy the house from him in the future. I mean, he's not the only person who might be affected.
And I would be more than happy to put in writing that if somebody bought his house and had a problem with it, I would take it down as well. Again, I'm not looking to cause trouble with this. It's the last thing I was looking to do.
No, let me just, Don, I know you want to speak, but let me just say one thing. Mr. Petrino, you made reference to a deed restriction on the house, that in the event that the house is sold, the deck would be removed.
Correct.
And that would be recorded, so we'd have an enforcement mechanism.
Correct.
Yeah, and I think personally, I think that's an acceptable situation. The fact that your planner, your engineer have testified doesn't necessarily mean the board would have acted positively on a variance like this, because we would have looked at alternatives to violating the setback. So I think it's after the fact. I don't think we need to debate whether this would have been approved by the board if you came before us, but the fact you've agreed to put a deed restriction on the property, which would be recorded, to me is a decent enough enforcement mechanism to allow it to go through, but that's just my opinion.
Mr.
Okay,
Cohen, I would
Don?
take it a step further and make that reciprocal. If for any reason the Evans decide to leave and there's an issue that stands in the way, I would remove the deck as well. And that's
Yeah.
it.
That's fine. That's fine. Thank you. Donna, did you want to say something, please? Donna? I don't think she can hear me. Donna? Yeah, please.
I'm just having can you hear me?
I can
You
hear
keep
you.
breaking up. but
You.
Okay.
You're a
I
little
don't
choppy there.
Yeah. Can you hear me?
Yes,
Yeah, we
well,
can.
I am having trouble. I know
you're really breaking up.
I
I'm
have a
sorry.
bad connection. I'm sorry. I'm having difficulty. What is the hardship here? That
We're not seeking a hardship variance. We're seeking a C2 or flexible variance, and
yeah,
and Mr. Falcone has provided the proof.
What is the hardship?
it's not a hardship variance. Those aren't the proofs we provided. And as a matter of fact, there is a section of the hardship criteria that we could probably satisfy, but it was easier to provide testimony on the flexible C variance. We had a purpose of the municipal land use law that we're promoting, which is the reduction in the loss of mature trees. We're saving mature trees. That's an environmental consideration built into the municipal land use law. And we're also retaining all the open space on the lot, which is one of the other things that the municipal land use law in the same subparagraph of the municipal land use law talk about. So we have support in the purposes for zoning. We've shown you the fence and the shrubs and the other things that mitigate any visual impact or negative aspect to the deck. And we've offered, even though I don't think it's necessary, we've offered to remove it when the house is sold, or if the neighbor sells his house. So I think we've provided all the proofs, and we've provided a mechanism for the removal of the structure if that's what the neighbor wants. So I don't think there's much left to be said, because the proofs are in, and the willingness to remove the structure is there. And I think we've demonstrated, this was not a purposeful act. We didn't intend to violate the setback requirements. And by the way, in other zones, in the zone that this lot is most like, because it's only 1 2/3 acres, the 1.5 acre lots only have a 15-foot setback. So the deviation would be less. Also, the other side yard is conforming, and we've tried to separate, this facility from the garage and that's on the other side of the lot, because they weren't really compatible in terms of the reason why we wanted this intimate space. So I think we've demonstrated that we're entitled to the variances.
I have a question. I'm all for preserving mature trees, but explain to me how this is preserving mature trees. It's encircling a couple, it seems, but I don't understand unless you would move it over and say, well, we had to cut down those trees, but.
Well, if we moved it over, this is the only place where there's shade. If we moved it over, we'd have to move it into open space. If we went to the 20-foot line and we wanted to keep it as close to the shade as possible, we would have had to remove trees. The picture that you saw that was, I think, Exhibit 1, showed you that the deck was built around the trees so that those trees are preserved. They continue to survive, and we are preserving mature trees. If we had to take the deck down, those trees wouldn't come down, only the deck would come down. The trees would remain.
I just don't see how that's preserving the trees. It's incorporating them and it's providing shade, but it's not inherently preserving trees. I don't see it.
Okay, I guess we'll have to agree to disagree, because we're not taking them down. So that would be the definition of preserving.
They would have been there if you hadn't built the deck, they would still be there. So building the deck does not preserve the trees.
Building
if the deck were in a different location.
If we built it in a different location and we put it on the entire deck on the property line, some of those trees would not have been maintained.
Well, that would have been,
Or you may have located it somewhere else if the trees were an issue.
Yeah, it's a big property. It could have been in a.
Yes, but we're
another
also
location.
trying to maintain the open space of the lot and preserve that aspect of the lot. And that is consistent with one of the purposes of the municipal land use law.
Yeah, I mean, I would argue, I understand what you're saying. I think we're calling attention to the trees. I think we're utilizing the trees. I don't, whether we're preserving them or not. Yeah, I get the distinction there. Important trees. They're important trees to my family, and we are using them in this case. We were using them prior, to be honest with you. They just happen to be in the most remote part of our property, and it's the only respite from the sun. So for us, it was about really taking advantage of them, using them. And I think that's what trees are for. So, I don't want to get caught up in whether they're being preserved or not. They're being appreciated.
Mr. Petrino, it looks like you have Mr. Evans. He's present. I don't,
Is he here?
I see his name appearing.
I am here,
Uh,
yes.
Okay, will we be able to see you, Mr. Evans? Can you have video or no?
I think my video will disrupt the dialogue. But if you can hear me, I'm happy to speak.
Is that acceptable,
Okay.
Karen?
Well, ordinarily, we would ask to be able to see the person that we're swearing in here.
Okay, I'll try it. I just don't,
Okay.
Let's see.
maybe we can do that temporarily and then.
There. How's that?
There you are, great. Mr. Evans, if you would give us your address, please.
I'm at 244 Lambert Drive.
And do you swear or affirm your testimony this evening will be truthful?
I do.
Thank you.
Mr. Evans, I just want to ask you one question. What's your view of the deck? Do you have an objection to the deck remaining? And did you hear Ben's testimony that he would remove it when he sold the house? And he also offered to remove it if you sold your house and your buyer had an objection.
Yes, I did hear that. And that was an agreement that Ben and I had dating back to October of last year. I also submitted a letter, which I ran by Ben and also submitted to the zoning committee. I think I sent it to Derek that detailed that agreement. And I just want to highlight some other agreements that we noted in there, which have not been discussed this evening, but I want to get incorporated onto the record. But that said, I conditionally approve of the deck, which I've told Ben. It is certainly most impactful to my property. Other properties don't see it. So some of the other conditions that we discussed and agreed to, which hadn't been discussed tonight, I wanted to get on the record, is that there not be any additional lighting on the deck. There are some tea lights there now. Those are fine, but I don't want any additional lighting. No, permanent music or speakers installed. We discussed that. No, other TV monitors or other electronics. And they've been consistent with this. They haven't, abused that. But one of the items that is still critical to me, which as you saw from photo number 2, looking at the deck and my house behind, is there is clearly an unobstructed view from the deck to my second floor, which is my daughter's bedroom. So not only looking towards the bedroom, but also her looking down at the deck. So when the Weisses are out there, she feels very uncomfortable. She pulls her shades. She doesn't want to be seen or see the family or guests there. So I did mention to Ben that I prefer having more mature trees installed either on his side of the fence or on my side of the fence, or both, to completely obstruct view from the deck to that second floor room and vice versa. That again wasn't discussed tonight, so I just wanted to get that on the record. But Ben and I did agree to that.
Yeah,
And Ben, that's agreeable.
100%.
Is that part of the deed restriction, or is that, you want that to be a condition of approval? I'm trying to figure out how,
Yeah, I think the items that that Mr. Evans just mentioned should be conditions of approval.
okay. All right.
And I don't know the process for
If an
having
approval's
that
granted.
followed
Right.
on,
Right.
but I look to your direction on that.
Thank you, Mr. Evans. Mr. Chairman, we have nothing further. You've heard from all of our witnesses. We're available to answer questions.
Okay, board members, are there any questions of the applicant, the attorney, the neighbor?
Yeah, I have a question about a few different numbers I see for I just wanted to get straight what the impervious coverage is, because I see in Derek's memo, there were, it said existing is 21.26, I think, and required is 19.5, but then in the drawings, it looks like it says it's 16% is, I guess the max, and then existing is 21.95 and proposed 21.97.
The existing was already a matter approved by this board. So what is the increase is from 21.26, which is the lawful coverage standard at this point for this lot. And it's being increased to 21.97%, which is about, which amounts to 512 square feet of additional coverage.
And actually, the permitted is 19.5%.
Right.
Percent.
Okay, so the 16 is wrong. It's
Yeah,
19.
I don't see the 16. I'm not,
It's on the drawings,
yeah, we're on the drawing.
in the zoning schedule,
I'm seeing.
On sheet 3?
Page 2.
sheet 3.
Sheet
Oh,
3.
It's on both, it's on both sheets, 2 and 3.
Oh, okay.
And it says maximum lot coverage 19.5. I don't see the 16.
Diane, can you put that up? I don't know that we'll be able to see the chart, but
You should be able to, yeah. Yeah, you got the chart here on the right side of the plan. Last line is maximum lot coverage. Yeah, you know, it does say 6. I wonder if this plan was revised. Could you go down to the bottom, all the way to the bottom? Yeah, yeah. Well, my plan says 19.5, and I know that 19.5 is the correct maximum, but that does say 16. You are correct.
Plans that were submitted to the zoning office reflect the 19.5 is required maximum, existing 21.26 and proposed 21.97. Maybe the plans got shuffled when they submitted for the
Yeah, something must have got changed, but
Okay,
it is 19.5 max.
okay.
sorry for that.
Mr. Bridger, I have a quick question for you in terms of enforcement. If the application is approved, do you want notice if Mr. Weiss decides to sell his house? Because I'm not sure how I'm not sure how you would know that it's sold. So I don't know how you would really enforce the removal of the deck. I understand, Mr. Weiss would say, well, he's aware of it, he would do that. But in terms of this being an enforcement mechanism, is there a way you would know?
No, as you know, perhaps a deed condition or restriction would come up in title, but
Well,
I mean,
unless you're put on notice that the property is going to be sold, I'm not sure how you would enforce it. I'm not saying that it won't happen. I'm not saying that Mr. Weiss won't follow the deed restriction. I'm saying that from your perspective, I don't know how you'd know that it was sold.
I mean, if they
Is
can,
there any sort of mechanism for the deed restriction to call out notification of the zoning officer?
Sure. If that's acceptable to the applicant, yes, that could be included in the deed restriction.
there was mention of if Mr. Evans sold his property, that would trigger some kind of removal of the deck or a discussion, but I don't really know how to enforce that, you know?
Well, it would seem to me that Mr. Evans would be able to inform his buyer of that, and then they would need to, I guess they could either contact you and say, I do want it removed, and I've asked Mr. Weiss, and I'd like you to get involved. So it seems to me that mechanism for enforcement is something that, as long as the new owner is aware of it, they can pursue that. Seems to me the bigger issue is if Mr. Weiss ever did sell his house, I don't know how you would know that. I mean, unless you're always looking at deeds that come in from the assessor, but I'm not sure you get those deeds anyway, so there's no reason why you should, so.
Well, but the deed restriction would be in the chain of title, and
It
the
would.
buyer would want to make sure, if that was a deed restriction, that it was enforced. And as to the adjoining property, maybe there's a way where the document that's recorded can refer to both lots so that it would be in the chain of title of both properties, Karen.
Well, I mean, it's possible that the buyer might like the deck. So, I mean, the buyer might say, well, I don't want it removed. Why would I do that?
Well,
I
we'll
don't
agree
want it,
we can agree to provide notice.
Okay, all right. So,
I may have missed it, but how was it discovered that this was out of zoning? Out of whack?
I received a complaint.
From a neighbor?
Yes.
Doesn't matter, I guess.
Right.
Somebody noticed.
Yeah.
Actually, I think I was the one who brought it up because I was curious what the setback requirements were. I think, Derek, I called you and asked. I think that's how it came about. I was not intending to cause this event. I was just trying to find out what the requirements were.
I stand corrected, sorry.
Anyone else have any questions, comments?
I just wanted to comment. I think it's interesting to note that, I don't know how often you guys, have hearings like this where the neighbors genuinely like each other. I mean, the last thing I wanted to do was create any issues for Greg Evans and his family. They've been great neighbors to us. They're longtime residents. I'm a longtime resident. We've always gotten along. When we sat down and talked about this, it was an easy solve. Greg, I completely commit to everything I talked to you about, including putting trees up, whether it be on your side of the property or mine, doesn't matter to me. And at the end of the day, this is about, we for great intention, we built a part of the property without knowing that we were, infringing on a setback and needed permits. So, I own that. But the only person that this impacts is Greg Evans and his family. And if he told me that, Ben, I just can't have it, I would take it down. And I told him that to his face. This isn't about, this is about being neighborly. And I think we're demonstrating how neighbors should act to one another. I mean, I think we found compromise. And I think that's the good that came out of all this, and Greg, I appreciate you getting on the call today. It means the world to me. And listen, if everybody on this board is okay with it, like Greg and I are, and we can move on, that's great. If not, I accept that as well. Did not do this with bad intent. And I did not think I was infringing upon anybody by doing it. So apologies for that.
Well, I take you on your word, and I think, in my opinion, the fact that you have offered, when you sell a house, to take the deck out, that will be, whatever the mechanism is, to allow that to be recorded, how that would, we, or you would contact the zoning officer or your title agent. I don't know the specifics of that. I mean, the fact that you're agreeing to that, and I just want to understand, and maybe Karen, you can correct me, we're basically being asked to retroactively, I retroactively approve the deck. And I hate to use the word temporary because that seems to be thrown around a little bit tonight at other hearings, but in a temporary situation. I mean, it's
No,
not a permanent
I wouldn't, well,
approval
no,
of the deck.
that's true. But I mean, as Mr. Weiss indicated, he currently plans to stay in his home for a long time. So I'm not sure that we'd use the word temporary. I think what we might, instead, it's better to look at it by saying, as Mr. Petrino indicated, the duration of this variance has some limitations to it, but it could remain for years and years. It could be another 15 years. It could be 20 years. We don't know.
Karen,
So, yeah.
Along those lines, one thing that I wondered about before we even started tonight, just having read about it, I thought, well, what if it's not, it's such a beautiful spot. It's the kind of spot that might be, a family home for several generations. Would that be considered a sale, or would that?
Well, I mean, I guess that's something we can talk about tonight. It's a good point.
I guess you could say change in title. I don't know the mechanism to do it. I understand the intent of Mr. Weiss. And I guess, again, the board has to really discuss this, but I understand the intent. It was, quite frankly, it seems to be an honest mistake. I'm not crazy about it, but it was, in fact, I think an honest mistake. He's done the best he can to rectify the situation short of taking it down. So, I mean, to me, it's an acceptable situation. I just don't know how to create the proper documentation to allow some of the remedies to happen.
Mr. Petrino, obviously, you would be preparing the deed restriction and
Right.
we would need to review it, but instead of saying if it's sold, if it just said if the ownership of the house changes, is that something that is feasible?
That's
or
fine.
That's fine? Okay.
Yeah, I think,
All right.
Karen, from my point of view, you and I and a title company will work out the details so that the intent that was expressed by Mr. Weiss can be achieved. So we will, we'll work it out. We'll come up with the appropriate language. We'll run it by title company. We'll run it by Derek, make sure he's happy with it. And I'm sure we can come up with a mechanism.
Okay.
Including, if I have to, I take it down right now. I mean, it's not about that. I just don't know who really benefits from that, because I don't think either of us had a problem with it. But if I had to, if Greg came to me and said, take it down now, I'll take it down now. I mean, this is not, there's no confrontation here. I think there's an easy way. I thought there was an easy way to do it. Maybe in my naivete and even doing this whole thing, maybe I thought this was too easy to resolve. But that being said, if there's a way, either, you and I can do this legally one-on-one, or if we do it through the deed, I don't care whether it's, reciprocal, all that, doesn't care. Again, I'm flexible with this. I quite frankly, I just enjoy the spot. I just would hate to give it up, but it is what it is. So I get it.
Well, I think, Ben, that we can we can craft a document that will achieve all of the goals that you and Mr. Evans have expressed.
Would it be acceptable to put a time frame on the period that these documents have to be submitted to Karen and myself, just because the deck's already built, you know? And if we go away from here, and I don't want to have to start enforcement again, you know? So
Well, what happens with the court situation?
Well, we would have
when-
to advise the court. I mean, that's another condition, but, you know, if the board approves it, we advise the board that, or the court that the board has approved the situation. We give them the particulars and, you know, I would hope that ends the court action.
Right. And we
Well, I mean,
can put a time period on the document. I think under the municipal land use law, you have 45 days to adopt a
Correct.
resolution if you
Correct.
were to agree to grant the variances. And certainly within that time period, I can find a very smart young lawyer in my office to do this correctly.
Are we in executive session or are we still in?
No, I think there's still, I think Mr. Evans was testifying as part of the applicant's case, so I
Yeah,
don't know if
we
there's
haven't-
anybody else out there. You haven't opened it up yet to public
Well,
comment.
we have to let Mr. Petrino, are you
Right.
done?
No,
with
as I
your-
said, we've completed our direct case.
Okay. All right. So now we'll open this up to the public. Is there anyone in the audience who's raised their hand or identified themselves as wanting to speak to this issue? Eve, Claudia?
I am not seeing anyone giving any indication that they want to speak.
Okay, so we'll close the public hearing. Mr. Petrino, before we go into executive session, do you want to say something that you haven't said before?
No, I don't want to prolong this. I know we're beyond your 10:30 stop. I think that Mr. Weiss gave an excellent summary. I don't think I can top that. So we just ask that you consider and grant our two variance requests. I have nothing further.
Okay, thank you. All right, let's discuss this. Anybody want to make a comment or a motion or whatever?
I'd like to make a comment. If we believe then and that this was an honest mistake and something that they did in good faith, and yeah, I don't buy any of the other arguments, like the fact that it only covers 40% of it, that we would have approved it anyhow.
No, I agree with you on that.
But if we agree that he made an honest mistake, I don't see any reason not. I mean, it isn't a huge big structure that's making a big splash back there. Why not just approve it and let him keep it? Why does he have to take it down if he sells it? Would be one question I would ask. And if it's going to be there for 5 years or 10 years or 20 years, why knock it down in 20 years?
Well,
Why not just approve it? Well, it's because it's not just between these two people. It's not, that's part of the problem. Is I think that I feel like the reason for, I mean, I see what you're saying in this case, but I don't know if we're in a position to.
No, I agree with you.
Impose that on people who we haven't met yet. I mean, that's part of why all of us have to think about the big picture and as well as I mean, I'm very torn because I totally agree with, take out the middleman and let neighbors kind of work things out, but we also have to think about the other people coming. And I'm a little concerned about the daughter who wants to keep the shades closed. I mean, it's not like nobody's being affected in a way right now that makes them unhappy. You know, that's,
Yeah,
that,
but they can see in the house from the swimming pool too. So I mean, that's.
Yeah.
I mean,
But Stephen, I appreciate that. And I do understand what you're saying too. I think the whole point with, you know, the selling of the house was actually brought up by Greg, and I understood it. Like, yeah, you trust me. Greg trusts me, but he doesn't, if I sold the house, he doesn't know if he can trust the other person, isn't going to do all the things that I said I wouldn't. So I immediately obliged because I understood that. So that's what we were just trying to solve to. But I do agree with you. I mean, relative to his daughter's bedroom, I mean, that could be resolved tomorrow. I have no issues with that, and I think he realized. I think he believes I have no issues with that.
All right, thank you. Stephen, I think I understand what you're saying, but we do have two neighbors that agree. We have the basis for an enforcement action if the house is sold, or if either house is sold, or if either neighbor decides there's some situation that would warrant the deck coming out. I think it's the best of I won't call it a bad situation, but we have an agreement on the part of two neighbors to solve a problem. Whether we would have approved this or not, I agree with Eve. That's for another discussion. I mean, that's not for this discussion. So I think, quite frankly, to simplify it, we look at this as some sort of agreement to allow the deck to remain right now that has some mechanism for the deck to be removed, and it's enforceable by the zoning officer. I mean, if I'm wrong, tell me, but I think that's really what it comes down to.
And I'm not against that. I was just throwing out the other idea. I mean, I'm not
No,
arguing.
I understand. It's kind of a tricky situation. But all right, well, if you want, do you have anything you want to add, or can we see if any of the other board members would like to comment?
Michael wants to say something.
Lost you there for a minute.
Now, Steve, he asked you if you had anything more to say.
Oh, that was just a thought I had, and I wanted to, it was just
Okay.
my point was that if we believe that Ben made an honest mistake, then why not just accept it?
And I do. All right, Michael, please.
Yeah, if this goes forward, just a suggestion for the lawyers to consider. I'm not real hot on us getting too involved in any agreement regarding Mr. Evans' property. Maybe you would consider those two parties, Mr. Evans, Mr. Weiss, executing whatever legal binding agreement between themselves and just submit it to us. And if Karen's satisfied with it and you're satisfied with it, and just kind of leave us out of that just document it. And that's that. I see it getting real complicated for us, dealing with a separate property. If you guys get an agreement you like, it's enforceable. It's binding on your successors, however you struck.
All right, good.
Can I just make
I
one?
agree with you, Michael.
May I make one comment on that? My only concern with that is that would probably require me to hire an attorney to review this document and to get that. And I really do not want to spend any money on it. So that's why I was looking for this method, this process to resolve it.
Understood. Okay.
That's valid. Is that it, Michael?
Yes.
Okay, thank you. Any other members want to comment? Okay.
I have one question, just a mechanics kind of question. The concerns that Mr. Evans raised with respect to no additional lighting beyond I think he called them T lights, the existing T lights, no speakers, no TV monitors, and the planting of sufficient trees and buffer to shield his daughter's bedroom. Are we considering those deed restriction or conditions of approval?
I would think, and correct me if I'm wrong, I would think they would be conditions of
Well,
approval.
that's what I was thinking. So, Mr. Evans, I mean, what that means, the difference is it's not in the deed restriction, but in the resolution that gets approved, it says this approval is conditioned on the following. So if you were to determine that things are happening in violation of that, then you could come to the zoning officer and say, gee, I thought these were conditions. I don't know if you have a thought on that, Mr.
Yes,
Petrino, but I think that would make more sense than sticking.
Well,
in the
yeah, I
deed.
said I
Yeah.
thought they would be conditions,
Okay.
and as conditions under the municipal land use law, they can be enforced by the
Right.
township.
Yep, okay.
Right.
Can we, for the sake
Okay.
of simplicity, limit this just to Mr. Evans' residency next door? Because it just gets messy. If he leaves, I mean, grant the variance. That's my opinion. The issue is right now between these two parties, we've crafted conditions of approval and a deed restriction, which seem to address all the concerns. But if Greg leaves, it's just, you know, the variance should be granted at that point, and that's my opinion. It just becomes.
Wait, say that again. I thought what Mr. Evans or somebody offered that if Mr. Evans sells or changes ownership of his house and that owner objects to the deck, then Mr. Weiss says, I'll remove it. If I'm told by the new owner, I don't like that deck, get rid of it. So if that's part of the deed restriction, I'm trying to figure out, Derek, you're okay with part of this, but that's the part of it that concerns you?
No, I'm just concerned that something can be crafted that covers that adequately, so.
Yeah, I was thinking more like if you sold your house, Greg, and somebody was saying, I'll buy the house, but I don't like that deck right there. I'm not buying it if there's a deck there. Then I would say I'd remove the deck. But if you sold the house and they didn't have a problem with the deck, and then 2 years later, they have a problem with it, you know, that's not what I was thinking. But again, I'm okay with that. I would even oblige to that.
Right.
My issue isn't, you know, so I have to take down the deck, I'll take down the deck. I just want to be able to use it as long as I could before I take it down. And if, you know, if I can enjoy it for a period of time, that's fine. I'm prepared to take it down if that's the case.
Again, Karen, I think we can
All right. Okay.
craft something.
And I guess we would include Mr. Evans then. He would also need to take a look at this, or?
If that's, yes, we would agree to that if
Okay.
that's the board's
Okay.
desire.
All right. I assume you want that, Mr. Evans, right? You'd like to see it?
Yes, thank
Okay.
you.
All right.
Okay, would someone like to make a motion? Anyone?
I make a motion to grant the variance for the previously constructed deck. And it be conditioned on the conditions we discussed, which is related to lighting, no additional lighting, no audio, no visual monitors, whatever, and that adequate mature trees be planted to shield completely. And that,
the deed restriction.
and then the deed restriction will be applied to Mr. Weiss's property.
Can I ask a question?
Yes,
sir.
There was mention of the trees being planted either on Mr. Weiss's property or Mr. Evans. Is that a decision that can be made now? Is there sufficient space on your property, Mr. Weiss, to do it, or?
You know, I was holding off, Greg, on that because I just planted those. I want to see if they would grow in, and I get it. They probably need more trees there. But I also wanted to get past this hearing too.
I'll get to you then.
But with all that said, I mean, we can look tomorrow if you want. I don't care if it's on your side or my side, to be honest with you. Achieves the same purpose. I mean, if there's room on my side, let's do it there. If not, do it on your side.
Thanks.
And I think, we have pretty good landscaping between our homes already. There just happens to be that area that isn't. So, I mean, it would be consistent with that.
I second Michael's motion.
And the deed restriction would be if Mr. Weiss sells the house or.
Well, I think we were talking about if the ownership changes, but that's something that it's a little bit different.
Right.
Ownership changing as opposed to actually selling it. You could gift it or give it to somebody. But Michael, you're saying are you also supporting that other side of the deed restriction, which would kick in if Mr. Evans is under contract to sell and his buyer says, I don't like that deck. I
Yeah.
don't like it.
Mr. Evans wants that incorporated, yeah.
Okay, all right. Okay,
I think we do too.
okay.
Okay, so we have a motion, we have a second. I think Karen, do you understand all this and
Yes, yes, I
Okay.
believe I do. And I have the tape in case I need to listen to anything again.
excellent,
so.
excellent. Okay, if there's no additional comments on the motion, then Claudia, can you poll the board?
Olson,
Yes.
Mr. Floyd,
Yes.
Mrs. Shriver,
Yes.
Ms. Chen,
Yes.
Mr. Stein. George,
Yes.
Ms. Diana,
No.
Mr. Cohen.
Yes.
Thank you.
You're welcome. Okay, I'm sorry I didn't do this earlier, but we have 2 additional hearings tonight, which we are not going to get to, and they're going to have to be carried, Derek, to when?
I think then we'll need to take jurisdiction. That way, neither applicant will have to renotice.
Okay,
So once we know the date, then we can go in order for each one to take jurisdiction of them.
Well, the next meeting is July 28th, the regular meeting.
Isn't there something else on July? That's
We already have
we Chief Lane.
we Chief Lane, yes.
Okay.
do we have on that date?
We Chief Lane.
Oh, okay. Okay. Well, we'll have Wheat Chief and these 2 additional hearings.
Okay. All right. So 46 Nassau Street, the noticing is in order. The board has jurisdiction. So I'm assuming it's acceptable to the board to take jurisdiction. That application, same thing with 193 South Harrison. The noticing is in order. Board has jurisdiction. So again, I'm assuming you're taking jurisdiction of that application as well. And I see we've got Mr. DeGrazia and we have the applicant. Will July 28th work for both of you? I think Ms. Knipe, her sound is not on, so.
I'm here. I'm checking right now to see if
Okay.
work. We're supposed to go to Sweden, but as you may know, it's pretty hard to get into other countries right now. So probably we'll be here.
Okay. So you're
I'm
okay with
very
that?
sorry.
And Christopher, is
Okay.
that okay with you?
I think so. I just emailed my client to see. Our planner's on. I just want to make sure she's available. Oh, Kate is not available. Great. Let's see. This is a retail store on Nassau Street, and I know that they want to open, so I'm trying to figure out if our planner can get somebody else at their office available. And you guys don't have any special meetings set up in between, I assume?
Too many vacations and
Yeah.
other meetings. There's SPRAB, there's 2 planning board meetings. There's other meetings I have to attend, so it's not looking good.
Okay. And I assume no one wants to take a cup of coffee and do it in 15 minutes? We can talk really quickly.
It's 11 o'clock already. I think
I
it's,
know. You guys stayed up to midnight the last time I was here.
I'll ask the board, do you want to start a new application? It's 11, gee, what is it, 11:06? It's a little late, but I'll defer to everyone else.
I'd be willing to keep going.
I would too, if they're gonna do it fast. You gave us a lot of paper. I was wondering why we had that much paper for that application. It looks pretty simple.
Well, how long do you think it will take you, Mr. DeGrazia, to present your case?
We just throw on our planner. I think she can do it in probably 10 minutes.
Yeah.
Okay, I mean, if everybody is okay with that, let's.
Are there members
Karen,
of
are
the
you
audience that
comfortable
want
with
to
this?
speak?
I'm
Steve?
sorry. Yeah, it's going to depend on the audience.
I don't know. It's hard. I can't tell. Is there anybody,
And
raise your hand if you know how to do that with the little icon at the bottom? If there's anyone who wants to speak to this one. I don't,
There are no hands,
yeah.
okay.
so it's just you guys.
I know. What about our court, Bradley? Are you still okay with this?
Well, the issue is, of course, I think Derek's pointed that out before, after 10:30, there's an increased charge for the court reporter. So we put that on the applicant, but I'm assuming that's okay with them, that they just would like to get this heard tonight, so.
Yes.
Okay. All right, so then for Mrs. Knight, you will come back on July 28th, and if there's anybody out there that was here tonight for that application, it will be heard on July 28th. And the board's going to proceed now with 46 Nassau Street.
Thank you.
Members of the board, this is Frank Petrino. I want to sign off. I want to thank you for your time and attention. I'm sorry that we went as long as we did, but thank you for your consideration of this application. Good night.
You're welcome.
Good night.
Okay. Karen, for the 46 Nassau, are the notices in order?
Absolutely. You have
Okay.
jurisdiction.
Okay, Derek?
He'll be
Oh,
back in
Derek.
2 minutes.
Okay, no problem. So we'll wait a second. Okay,
Can we bring our planner up? She's in the attendees, I believe. It's Kate Keller.
Got it.
And I'd like to introduce my colleague, Jess Peslak, who's going to just take you through the application.
Got it. Hi, everybody. Hi, Christopher.
Hello.
Hi.
And thank you all very much for, Kate, I promise 10 minutes.
That is fine. I'm happy to go through this.
So ordinarily, we would have Derek go through his memo. So that's normally the order the board would like to follow. If you want to deviate from that, you can, but usually he kind of puts it in perspective for you.
He's
so-
back. He's
Okay,
back.
great.
I'm happy to
Okay,
wait a
good.
minute. I think that would be good for the board.
All right, Derek, if you could give us a summary of your memo, please.
Yes, sir. Applicant JND Incorporated is the applicant. PS Palmer Square Land, our limited partnership, is the owner of 46 Nassau Street. He's seeking a use variance pursuant to NJSA 48:55D-71 and related site plan application to permit the partial conversion of a retail use to an office use in a zone where such use is not permitted on the first floor. Applicant is proposing a retail eyeglass store. A portion of that space will be utilized as a medical office for eye exams. Property is located in the central business zone and is subject to the use and bulk regulations in accordance with section 17A 304 and 309. The applicant proposes to utilize the existing 1,928 square foot retail space as a retail eyeglass store with an eye doctor's optometrist office occupying 219 square feet of that space. They've submitted the required site plan and requested numerous waivers, which staff has no objection to since there really are no external changes other than signage. And the proposed first floor use is not permitted in accordance with section 17A 305, section B4, which precludes office use on the first floor. It is permitted use on other floors. As I mentioned earlier, a D1 variance is required. The applicant should address special reasons to grant the relief requested as required by statute. The special reasons must be shown to be unique or peculiar to the property for which the variance is requested and not generally applicable to neighboring properties. They should address reasons why the strict application of the zoning prohibition of the requested use or development would deprive the applicant of the reasonable use of the land or buildings involved, and they should provide evidence that the requested relief may be granted without substantial detriment to the public good or impairment of the intent of the zoning plan, the master plan and zoning ordinance. And that's a quick synopsis. If you have any questions, I'd be glad to address them. Thank you.
Any questions of Mr. Berger? Okay, Mr. DeRezia, 10 minutes. Go for it.
Okay, good evening, everyone.
Pressure.
Oh, good evening, everyone. Thank you for staying on. I appreciate it. I will keep this brief. For the record, my name is Jessica Peslak. I am an attorney at Faegre Drinker Biddle and Reith, and I represent the applicant, JAND Incorporated, also known as Warby Parker. We are appearing before the board tonight seeking use variance approval in relation to the property located at 46 Nassau Street. The site is located within Palmer Square, a lively Princeton shopping and dining area. The proposed use is a retail store that sells eyeglasses and offers medical eye exams. Because there is a prohibition against medical and dental offices on the first floor, we are seeking a use variance. The intent of the Princeton Code is to have retail and other active uses rather than offices on the first floor. However, the proposed use fits squarely into the category of an active retail use with displays visible from the sidewalk, inviting the public into the store to shop. There is no need for a strict interpretation of the zoning prohibition, as the accessory medical use does not change the ultimate purpose of the store, which is a retail store that sells eyeglasses. Importantly, we are not proposing any expansion to the existing building, and instead will utilize the existing space. We are also not proposing any external changes, except those that have already been approved by the HPC for signage, awning, door handle, and lighting. Lastly, with a lot of retail spaces empty during this COVID pandemic, we think this is a wonderful opportunity for the municipality to allow this site to be utilized by a business that will invite community members and visitors alike back into the downtown area. This is certainly not the type of use that was intended to be prohibited by the code. And with that, we can start our PowerPoint presentation that we have for the board. We can swear in Kate Keller, our licensed professional planner.
Ms. Keller, do you swear or affirm your testimony this evening will be truthful?
I do.
All righty, and would you like this then marked as Exhibit A1 collectively, all your slides?
Yes. That's perfect.
Okay, great. All right.
And Kate, can you tell the board your educational background and your qualifications?
Sure. Hello, Chairman, members of the board. Thanks again for letting us go forward tonight. My name is Kate Keller. I'm an associate principal with the firm Phillips, Price, Greigel, Laney Hughes, based in Hoboken, New Jersey. I'm a professional planner in the state of New Jersey and also a member of the American Institute of Certified Planners. I hold undergraduate and graduate degrees in planning and urban studies from the University of Pennsylvania. And I've been accepted as an expert witness in approximately 40 municipalities across the state, including the Princeton Planning Board and other municipalities in Mercer County.
Okay, and we would accept you as an expert witness, so please proceed.
Great, thank you very much. So thank you. I think Jessica just gave a great introduction. And so we're just going to have a brief presentation here, which I think will introduce you to this project. And as well, I will put the planning proofs on the record. So as mentioned, this is a property located at 46 Nassau Street, as seen on this map here on slide 2. It was formerly utilized as a Club Monaco clothing store. As you can see here, and as you're aware, this is located in a prominent downtown location within the Central Business District and also the Central Historic District. The site is currently a joint occupancy structure with residential above and a commercial space on the ground floor. It's similar in that regard to neighboring properties on either side of it, such as shown here on slides 3 and 4. Other storefronts and mixed-use buildings within Palmer Square and adjacent properties. So the property in question, as seen on this slide, is 46 Nassau Street, and Warby Parker is now proposing to locate a eyewear retail store within the existing 2,000 square foot commercial space on the ground floor. So the proposed use, as was described in the introduction, is really a retail store that has medical office and optometrist on site as an accessory to the retail use. The medical use is not permitted. It's only permitted above the first floor in this zone. So that's why we're requesting D1 use variance relief. In this case, the proposed medical use would be just about 10% of the floor area, which you can see in the green on this slide 6. And where the green on the left-hand side of the screen represents the floor area that will be used for the optometrist, where the rest of the the floor plate will be used for sales and retail and display of merchandise, etc. So since clearly retail stores are permitted and encouraged in this zone, the medical use is really an accessory to this use. No increase to the floor area is proposed and no intensification of this, this site either. So just to briefly address the positive and negative criteria, in terms of the positive criteria where special reasons shall be advanced, in my opinion, this property is particularly suited for this proposed use where it really will function as a retail store. The medical office is just a component here, and I think both in function and appearance, the resulting store will be much more characteristic of a typical Nassau Street or Palmer Square retailer than the medical or any type of office use that the ordinance was seeking to prohibit in this location. So, the retail sales is the vast majority of this first floor area, and Warby Parker's sells both, prescription and non-prescription eyewear on either an appointment basis for the doctor's office, which is probably about 20-30% of their business based on existing stores. But generally, that leaves 70 or 80%, which will be walk-in customers who will really, be attracted by the new facade and the display and the storefront and come in here. The optometrists themselves would be the only dedicated employee of the medical practice, where the Warby Parker staff would serve as reference and receptionist. So it's not going to bring in additional employees like as another type of use would, or if it were a standalone doctor's office. And I think you can see with regard to the building's exterior here on slide 7, which as mentioned, has been approved in terms of signage and facade alterations by historic preservation already. The renovations are really minor in nature, and it's really a repurposing of the existing storefront with no substantive changes to the historic building. Really just the changes like the doors, painting the doors and windows and replacement of hardware and awning are just to, really represent Warby Parker's brand while remaining in character with the surrounding storefronts. So I'm just going to go to the next slide, which is the rendering of that proposed storefront, which has been approved by historic preservation. And I think that it's typical of storefronts in the area, which it's inviting. It has display inside. It's clearly a walk-in environment where any pedestrian would feel welcome in. And again, I would also mention that the store will operate in hours that are much more typical of a retail use rather than a doctor's office. So just a quick review of Warby Parker does have these, stores that are both retail with a medical component in all kinds of retail districts, including historic districts here, like on Upper East Side and in Palo Alto, California, and then in outdoor shopping areas and in indoor shopping areas. And I think in all of these cases, you can see that these are primarily retail stores that have been designed in context with their surrounding area. And I think, in terms of particular suitability, this is a bustling mixed use area where the proposed use will serve members of the community and for both eye care and retail sales. In terms of purposes of zoning, I think that this promotes, in purpose A, I believe that it promotes the public health, safety, and general welfare in terms of this is a health service, and it increases the vitality of downtown Princeton in a manner to promote the general welfare. It provides sufficient space for a variety of commercial uses. In this case, it's 2 different types of commercial uses, which are really symbiotic in nature, but are under one roof here. And finally, in the same context, it's for purpose M, which is to coordinate land development with a view towards the more efficient use of land. Just briefly to address the negative criteria, I don't see any substantial detriment to the public good associated with the granting of this variance. It's consistent with the land uses in the general vicinity and form and function, and will further diversify Princeton's retail environment. It remains in character with visually in character with surrounding properties, and it won't result in an intensification over the prior retail use since there's no additional floor area being added. And I think in terms of intent and purpose of the zone plan or zoning ordinance, I see no impairment here. The 1996 master plan and subsequent reexaminations and ordinance amendments have stressed the importance of maintaining a diversity of retail stores within the CBD that will complement existing and new residential and office uses to form an active and vibrant downtown. And I think that this is a unique type of retail where the medical component is really intrinsic in it. So in this case, Warby Parker can provide a necessary service to their customers while having an optometrist in the store. And meanwhile, having the optometrist in a retail store mitigates all the traits that are typically associated with a daytime office use in a retail environment, namely, hours of operation, no weekend use, not open for walk-ins, et cetera. So I think in this unique situation where both the retail and the medical use will function more efficiently in combination than would individually, speaks to the positive and negative criteria for granting this variance. So I have nothing further. Woo.
Thank you.
Yeah.
Can you take the storefront down from the screen, please? Thank you. That was brief. Good. Do any board members have any questions of this witness?
I do. Warby Parker is extraordinarily popular these days, and you showed a bunch of stores. They must have stores all over the country. Is it typical that they only have one optometrist in the store? Or is this, my concern would be that one seems fine right now while they're building, but next year you're going to need 2 offices or 3 people.
I can't speak for specific other stores, but I know in this case that Warby Parker is intending to start with fewer hours for the optometrist or fewer days of the week. So that's where the expansion will occur. Because the optometrist will, be at the store for more hours or 5 days a week rather than 4 days a week, really. And I think in this case, the store won't be built out for that, and they would have to come back and get another use variance in that case if they were choosing to add that, because it's not really part of this application.
I have a question possibly to you and or.
You got to speak a little louder, George.
Yeah, I have a question that may be to.
Oh, wait. Okay, go ahead. I'm sorry.
Can you hear me now?
Yes.
Yes,
Yeah,
I
okay.
can.
Yes.
All right, the question basically is, this runs with the property, not with
Yes.
the tenant.
It runs
And
with the property, yeah.
So, I mean, if they move out and somebody wants to bring in a colonoscopy expert, they could do it. Is that correct?
No, I would say no. I would say that if somebody else comes in that has a largely retail component, maybe, I'm going to pull this out. Maybe a podiatrist who sells shoes and it's all shoes on display and you can come in and buy them. But also they're going to have an office which meets the same criteria that is being presented to you. Then I would argue the zoning officer would say, yes, you go ahead. You don't need any other approvals from us. But
So
this is not an
so your
approval
point
that's
is-
going to allow a freestanding doctor's office. No, no.
But I mean, your point then is if you have a retail operation and a medical use that's integral to the retail operation, then it's okay. But if someone was selling greeting cards and they wanted to have a little doctor's office in there, why couldn't they do that?
Because that's not what's being approved tonight. You're granting a use variance for an accessory medical use for use that's retail with a complementary medical use, which is limited in size. It's one optometrist. You're talking about two unrelated uses, and someone says, well, what's the problem? I'll have retail, and then what I want to do is like rent some space there to a doctor. So I think the circumstances in which someone else would take this space and not need further approvals, I mean, it's going to have to be very similar to this for another tenant to be able to say, I don't need anything else. I'm the same. I'm just not, I'm not selling eyeglasses. I'm selling something else. And this medical doctor is directly integral to what I'm doing here because I have mainly retail.
If we can put that in the resolution, then that answers my objection.
So Karen, can you,
Okay.
I mean, obviously you can reference the square footage that's in the application.
Right.
And I think that kind of makes it very unique to this specific spot. And it's highly unlikely that, I mean, if another eyeglass retailer came in and it works, but there's not a lot of other options that it's going to be transferable to, but that's a great question.
Okay.
Okay. Stephen, I'm sorry, I didn't know if you finished your question before I allowed George to speak.
Oh, I did. Thank you very much.
Okay. Okay. George, are you done?
Yes, I am. Sorry, I interrupted.
Okay. Any other board members have any questions? Okay.
I guess just along those lines, if I think what we want to think about is, would there be any unintended consequences? And I can't think of any, but other, George's is in that vein, but I can't think of any that would be our concern. Seems like a good idea to me.
I think this is a very attractive use for downtown. I mean, it's a type of business we don't have. It's going to bring, I believe, more people into the central business district. I think it's going to be very nice. Board members, any other comments? Okay, Ms. Preslak, did I get that right?
Yes,
Do you have any other witnesses?
No,
Do you
that
have
was
any
all
other
the
witnesses?
testimony. That was all the testimony
Okay.
we had prepared for tonight, Mr. Chair.
Very good. Okay. Hearing no more testimony, I'm going to open this up to the public. Do we have anyone who's identified themselves as wanting to speak?
I see no hands.
Okay, I'll close the public portion of the meeting. Again, Ms. Preslak, do you have a closing statement you would like to make?
Sure, real brief. I would just say that this proposed retail eyeglass store is exactly the type of use that is envisioned for the downtown Palmer Square area. This use will help bring members of the community as well as visitors back into Palmer Square for various shopping and dining activities. Especially during this COVID pandemic, this is a wonderful opportunity to allow the site to be utilized and by this vibrant and alive retail store. So thank you again for bearing with us in this application and staying on.
You're welcome. And thank you for being brief. Okay, let's go into executive session Board members, questions, comments, motions?
I think it looks.
I'll move to approve.
I'll second it.
Okay, we have, Karen, we've got conditions on this that will incorporate in the resolution.
Yes, I think just mainly making clear why it's being approved and that the medical use is accessory and integral to the retail use, and we'll reference the
Right.
square footage and so I think that would cover what the board discussed tonight.
Okay. Okay. We have a motion and a second. Okay, Claudia, can you poll the board?
Sure. Ms. Coulson,
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Ms. Chen,
Yes.
Stein,
Yeah.
Ms. Deanna,
Yes.
Chairman Cohen.
Yes.
Thank you.
Okay, thank you. Thank you
Thank
for being brief, and I appreciate it.
thank you
Okay,
guys very
Thank
much.
you.
Yeah, you guys are wonderful. We really
Yes, thank
appreciate it.
you.
You didn't have to stay, and that was really a great thing. Thank you. Really appreciate
When
it.
will the store open?
Sooner
Good
now.
question.
Do you need a new pair of glasses?
I
I'm
think
just curious how long it'll take.
Yeah, I don't
I
know.
don't think very long.
They've already started all their interior work, so they're in
Yeah.
their plans are being reviewed, so.
Thank you.
Not long, not long.
Mhm.
Do
Okay.
you have a second just to poll the board on returning live?
Yes. Okay, we're, thank you, Mr. DeGrazia.
Thank you again. Have a good evening.
Thank you.
You're welcome. Okay.
And actually, I hate to interrupt. I think probably we could let the court reporter leave now
Thank you.
because we're not
Okay.
listening to any. So Lisa, it's okay if you leave us at this point because all we're doing now is talking about non-applications.
All right. Good night, everyone.
Thank you.
Good night. Thank
Night.
you.
Lisa.
Thank you. So, okay, well, board members, how do you feel about continuing our Zoom or suggesting to the governing body that we possibly go live again?
What happens with the public attendance in that case? How is that
What
managed?
What happens
Excuse me, I just want you to know that you're still live and there's 1, 2, 3, 4 people that's still listening.
All right.
Actually,
Well, I mean,
only
this is
2 now.
it's still a public meeting, so
Yes.
people are entitled to listen. So,
I just want to remind everybody.
okay.
Thank you.
Okay. So so can you repeat that, Bernice?
I was questioning how does the public attendance work in that case? It's just full capacity back to.
Well, I think at this point, and correct me if I'm wrong, Derek or Karen, we basically just have to suggest to the governing body that we feel it's appropriate for us to be live again, and then they've got to work out the logistics of social distancing, capacities, where it's going to happen, whether people are still going to be allowed to testify via Zoom, all the particulars to this.
Bernice, I think right now under the governor's, I think his most recent executive order, municipalities can still impose mask wearing if they feel that's appropriate. So the governor's given local governments like a little more flexibility in that area. So I guess there could be some form of social distancing, like every other seat, but I think Steve's right. That's going to be something for the governing body, I guess, to think about.
Yeah, I mean, this is going to affect, if we do this, the planning board may chime in. You know, they may have feelings on this, and the council, you know, how they want to handle all these hearings.
I mean, it's the
So,
same thing
but-
with the dais, because there isn't sufficient room
Yeah, exactly.
to have any distancing, really. A little bit, but not much. So I guess those are
There
all
are many,
things for the
right.
governing body
Right.
to consider. But I guess maybe, Derek, you're just looking to see what's the general, if there is a general consensus that.
Yeah, and you're correct, Karen. There would be a lot of, thinking about how social distancing occurs and if it's a hybrid with Zoom. I mean, just tonight, though, the technical difficulties are elongating the meetings and, it's just not a good way to do a legal proceeding. So,
yeah.
But
And I do think that trying to combine it, Zoom and in person, I'm not sure how members of the public would be able to see then if somebody is testifying via Zoom. Board members could from the dais with a laptop, but I'm not sure how the public would unless we can beam it onto the screen. So that if somebody said I'm testifying from, my home, well, how would everybody see it? Or if they say I'm going to share my screen, fine, but everybody sitting in the audience would say I couldn't hear it or I can't see it. So I don't know if it's even more trouble. I don't know.
I think we ought to do one or the other.
Yeah.
I just, as a minority opinion, I'd like to say, I think this works pretty well. I mean, I know it goes long, but I like being able to pull up all the paperwork on my screen while people are talking and look at it and check it and,
Yeah, I think there were some glitches tonight, but I don't know that it necessarily goes longer because I think in a way sometimes in person, the public part can be a little harder to manage. You have some technical control over that, but I mean, there's other reasons to do it in person, but just in terms of that, there's some aspect of control.
yeah, so I think it's either all or nothing. That's not a hybrid. Either we go back to the regular meetings that we keep.
Well, why don't we just go around and ask, so Stephen, you would rather keep it the way it is?
Well, or go back. I'm not opposed to going back. I'm opposed to a hybrid. I'm opposed to something in between.
And
that's all.
Okay. Eve?
It sounds like it is complicated for the staff and more time consuming for them. And so I'm for going back to being in person if assuming that I'm for saying I'm willing to go back in person and not speak for the whole group, but if we all agree to that, then it'll be up to council and whoever else to decide when and how we can do it. I think that's what we're being asked to do tonight. And I'm willing to go back as soon as that can be worked out.
All right.
So it's premature to make that decision.
Okay. Michael?
I defer to mayor and council and the administrator. I can do it either way, but I think it's all their decision.
Donna?
I agree with Eve and Steve. I think we go back or we keep doing what we're doing, but not a hybrid. And I think if we go back, we just want to know that we're going back to a condition that we all think is acceptable. Whether it's mask wearing, whether it's distancing, it's just something that everyone's comfortable with.
George?
Yeah, I'd like to go back, but is there a way that one can say you have to be vaccinated to be there in person?
You know, I think maybe we leave the particulars up to the governing body. I mean, I guess it's, correct me if I'm wrong, Derek, we just want to, you're basically looking to see what we would prefer, as we said, the logistics and the conditions and everything else would be up to the governing body. But, and I'm sure they would have discussions with the board, various boards, as they do this. You know, there are so many other factors now with this new strain of the virus and
Yeah.
everything else. It's, you know, but it's just a matter, do we want to continue Zoom, or do we think we're getting to the point that the complications to this would warrant us to at least lean in direction of going back to the way we had it, or some variation, which would be up to the governing body.
Best argument for staying on Zoom is that I only have to walk 5 feet to get to my bedroom after a meeting's over at 11:45. I don't have to drive home.
Whatever. All right, Bernice, I think you,
Oh, yeah, I'm okay with going back. I hope that we still all get our documents electronically. And I'm just wondering how that works with everyone being able to pull, do we bring our own device then so we can pull up things as we want? How would that work?
We'll have to look into that. I mean, there are monitors at the council, but I don't know. I think it's just what's being put on the main screen, you know, when somebody puts up a exhibit. So, but there is a movement. I know.
Right, but there, yeah, sometimes you want to look at something that they're actually not
Yeah,
exhibiting, you know?
you know,
Mhm.
benefit. Yeah, sure. Yeah, that's something we'd have to look into. You know, I know they want to get away from paper plans just because of the environmental issues with it. So,
Right.
Sure.
You could always bring your own. We could give the information digitally, and you could bring your own laptop. Or I'll look into you know what options are out there for that. That's a great point, though.
yeah. And Claudia is doing a great job distributing everything, and I know it's a big job. Personally, I'm comfortable either way, but I think the complications created by, you know, these Zoom meetings, and I mean, I've had problems connecting a number of times, and for that I apologize, but it happens. So I don't have a problem with a lot of, again, there's so many other factors to it, just, you know, other than the desire to do it. So, all right, that's it.
Thanks, everyone.
Okay.
Thanks. Good night.
Thank you again. See you next month.
Thank you.
Yeah, bye-bye.
Bye-bye.
Bye.
You know, Mr. Weiss from Lambert Avenue, he said he's a beverage man. Yeah, he sold his main beverage, which was BAI, B-A-I.
I wondered. But
He's
that's
the guy,
not what he said. That's not what he
because
meant.
he doesn't own it anymore. He just named his company and said he's a beverage inventor or whatever. So BAI isn't his current ownership, because he sold it to Snapple a few years
The
ago.
guy who invented it in the basement in Washington Oaks?
That's him. That is him.
Who was that? Ben?
Yes.
Really?
Go. You can go Google him. I kind of wondered who he was when I was out at his house. You know, I talked to him a little bit, and so I just wondered. And I Googled him, and there he was.
So, Michael, do you know, I thought, do you know Barack Bar Cohen? Was he also in on that, or do you? Because I thought he was also part of that, but I think Ben is the guy who invented it in the basement, at least the legend.
And there were articles there on him, one by Princeton Magazine, so it attributed it to him as sole inventor. So no one else's name was involved in it as far as the article said. So that's all. That's who he was.
That's who we were dealing with.
Yeah, yeah. Yeah.
All right, good night.